my lord. I will file the constantly in course of today, my lord, and maybe taken up 1 week after. I have some personal difficulties for 1 week after, my lord.
Item 28 को year case
पूर्ण case अवश्य.
केबे
2003, my lord.
No.
Or next week, my lord.
No, let it reach, we'll see. Let it reach.
Then, my lord, not today, any other day.
Yeah, it will come. It is for the entire week.
Yes, madam. Tomorrow at least.
Yes.
Tomorrow, my lord.
29. 29 of the weekly list. I missed my file, maybe taken up tomorrow.
It is in the weekly list. If you are not there, it will be automatically passed over till Friday.
I am permitted to take it in pen drive because I have the pen drive.
Yes. We'll see.
Item 34, respondent number 1.
Item
29.
Yes.
I am for respondent number 1.
My friend is.
So.
Take a file time.
Item 29. कौन Why are you wasting your time unnecessarily?
Item
you have nothing to
34.
say.
Item 34, my lord.
Yes.
Therefore, next week, my lord.
तो कोई और matter.
19 matter, my lord. TRP sir, Mr. Mahanti is out of station, my lord. Mahanti again.
1 week after.
To pardon, my lord, 2017 writ petition. During pendency of the writ petition, another advertisement is issued by the authority to appointment in the copy number 6 here. So, file the I also.
Yes.
And both matters same. So, like tomorrow,
Allow for them.
there is someone.
Again, keep more conversation. Let's do it. Yes.
Quickly tell item number 1.
Anganwadi worker, my lord, not allowed to work and also not getting anything.
Yes.
You have not received any instruction, but the prayer that he has made transferring, that may not be possible.
What transfer?
He seeks transfer because he is not able to work in the center he has been appointed. She has been appointed.
Yes. So you'll have to take instruction. The order was that
Yes.
that despite being engaged as Anganwadi worker, the petitioner was not allowed to join apparently because of her caste. So that has to be, you have to take instructions in this regard.
Yes.
I'll call it next week, so the order be complied with. All right. Let's just, as requested by Learned State Council, let's this matter next week. The previous order be complied with positively.
Item number 2.
As per of CMC number 49 of 24 from Patnagad FTGM to FTGM Bhavanipat. But
Yes.
Another TRP at the instance of wife has been filed. Maybe tag with that case, ma'am.
It's filed. Yeah. Let's this matter tomorrow along with the TRP take. TRP na TRP CRL?
TRPC, ma'am.
TRPC number?
At the instance of wife.
36 of 2024. Yes.
Item number 3.
Item number 3, my lord, mechanically passed over.
Pass out.
Item number 4.
Pass out.
Item number 5.
This transfer application has been filed by the husband, though it is a matrimonial dispute with the opposite party number 1 with the wife. Ordinarily, choice with the wife lies with the choice with the wife. But in this case, what happened? The wife filed a case at Khoda on section 9 of the Marriage Act.
Yes.
Both of them are serving at Bhubaneswar. The wife is serving as OU2, and whereas the petitioner is serving as a branch manager in Nationalist Bank. So for the sake of convenience of both the parties, if the case will be transferred to Bhubaneswar, it will be more convenient. That's why I filed the application. I submit that let your lordship issue notice to the opposite to know why and what for she is interested to prosecute the case at Khoda instead of Bhubaneswar. That is the question involved here. It is convenience of both the parties. They can prosecute their case because they are posted at Bhubaneswar.
It is your submission that she is residing at Bhubaneswar.
Bhubaneswar, serving as in the OMT,
OUT.
and the husband is serving in the bank at Bhubaneswar. Both are at Bhubaneswar.
All right. Sri S.C. Mahapatra, Learned Senior Counsel, appears on behalf of the petitioner and submits that the petitioner is sorry, that the opposite party wife is a resident of Bhubaneswar, being an employee of OUAT. Stop. The petitioner is also residing at Bhubaneswar, being an employee of a bank. Stop. Bank though. Issue notice to the opposite party by special messenger, the cost of which shall be assessed and deposit be made by tomorrow. List this matter, Arrow number
Till
Huh?
then,
9 September.
till then interim.
All stay.
Item 6.
Pass over.
Item 7.
I beg your pardon, my lord. I am
Yes.
submitting from BC Dhenkanal, my lord.
Yes.
Lord, this petitioner is the legally married wife of the opposite party who has filed this transfer petition TRPC and along with the IA for stay of the execution proceedings filed by the OP husband before the family judge Jaipur. There is there is a case pending before Sambalpur filed by this present petitioner under section 125 of CRPC for maintenance, wherein the opposite party has already appeared and contesting the case. Now he has, after filing of this petition by the petitioner, he has filed us to harass the petitioner, filed one CP before the family court Jaipur by 29 of 2024.
All right. Take notice. Issue notice.
And stay of the proceeding.
Issue notice by speed post, fixing a short returnable date. Requisites be filed within 3 working days. List this matter. 28th October. Stay.
Obliged, my lord.
Item 8.
I may please your lordship.
Yes.
The petitioner is the wife filed this transfer petition which has been filed by her husband before the family judge Cuttack. That is case number 349 2024 under section 13 of the Hindu Marriage Act. And another case that is under section 9 has been filed in this Kendrapada before the Kendrapada family judge by the petitioner wife. That is why the petitioner sought for this application to transfer the CP.
All right. Take notice. Take notice. Take notice.
And stay.
Notice.
I
Stay.
have filed stay.
Yes. Notice stay 28th October.
Item 9 pass over.
Yes, pass over.
Item 10.
The order dated 5/11/2022 passed by the Law and Additional District Magistrate Nabarangpur, your lordships, and kindly see Annex 7, page 85. Your lordship,
Yes.
and here the Law and Magistrate has stated that the
No, what is the case? What is the case?
the
No, what is the case? What are the facts?
Tax your lordship is the Anganwadi worker, your lordship. The petition of applied the Anganwadi worker applied within this period, your lordship, and submitted all the documents. Kindly annexure 1, your lordship. Annexure 1. Page annexure 2, page 19.
So what happened? You were selected. You were not selected.
I have not selected, but
So,
I have
the private opposite party.
as per advertisement. I have submitted all the documents. I have the belongs to the Anganwadi center. Konsariguda Anganwadi center belongs to the
Yes.
village of the.
Yes.
And the opposite party who has the continuing his service, as he is not the belongs to the Anganwadi center. He's the residing. He's the far away from the 3 kilometer distance, another village, your lordships. But the petitioner is the submitted all the documents, residential proof attached, proof of the date of birth attached, and caste certificate and other documents. At the time of the application submitted, at that time she has attached all the documents. But the Law and Magistrate, basing upon the submission of the your lordship certificate of date of birth proof and application has
No,
been
no, no.
rejected, your lordship.
Then come to the
Fact
point.
27.
They come to the point. You were not selected.
No.
On what ground?
no residential certificate has been
All
attached
right, all right.
and no date of proof of the attached, Your Lordship.
So what is your case? You had submitted all the
All
certificates.
the documents
They were not considered.
considered.
Let us see the appellate court's order.
Page note 25.
Hmm?
Page note 25.
Yes. 25 to last year, peruse the application copy of the Anganwadi worker registration application downloaded from the portal and submitted by CDPO Tentuli Kunti, wherein it has clearly mentioned that no resident certificate has been attached, no date of proof birth has been attached in proper column.
Yes.
So, they have downloaded it from the
Your
computer.
Lordship, Annex 2, I have submitted all the documents attached in the below. Below
Yeah, it
this
is-
line, attach the documents, all the documents.
Find out,
attached.
find out. This is a factual dispute. Anyway, you find out. According to the petitioner, she had submitted all the relevant documents by uploading the copies of the same along with her online application form. Stop. Her candidature was rejected on the ground of non-submission of the relevant documents. The appellate authority, after perusing the purported downloaded registration application, found that no resident certificate had been attached and no date of birth proof was also attached. So, the counsel for the petitioner forcefully contends that this is an erroneous finding, as the petitioner had uploaded all the relevant documents at the relevant time. Stop. Learned State Council shall take specific instructions in this regard and apprise the court accordingly, if necessary, by filing an affidavit. List this matter on 23rd September.
Sure.
Item number 11.
Yeah, that's all.
Yes.
Item number 12.
Vigilance. In this case, the limited grievance of the petitioner is there, my lord. The candidature of the petitioner for the selection of Anganwadi worker was rejected on the ground of outsider, my lord, without considering the residential house situated within the jurisdiction of the Anganwadi center.
File an appeal?
No, my lord. May I permit?
Yes.
Annex 6, page note 27 is under challenge, madam.
27, yes.
It is a notice
The notice number only.
wherein it is indicated that she is not belonging to that particular.
per the
section.
enumerated
So we have
officer
every
of-
right to file an objection, madam.
You file an objection.
Page 28, my lord, kindly have the class.
You file an objection.
সেবা অঞ্চল পরিসরভুক্ত হইনথিবারু দরখাস্ত নাকচ করাগলা।
No, say,
My limited grievances, my lord. The kindly have a glance for a moment, my lord. Annexure 5. Prior to the selection of the Anganwadi center, the advertisement, issuance of advertisement, the local sarpanch has also given a letter to the CDPO that my residential plot stays.
That is to be considered by the authority.
Only my there have to field inquiry has to be conducted.
No, you file an objection.
Yeah.
You file an objection to this
Selection
notice.
committee before this.
This notice is inviting objections.
Yes.
You file your objection. The petitioner is aggrieved by issuance of the notice dated 7/8/2024, whereby her application, her candidature for Anganwadi worker of Kojaga
Say, say, okay.
Potisari 1.
of Patisari 1 Anganwadi Center was rejected on the ground that she does not belong to the service area. Stop. According to the petitioner, this is factually incorrect, as no field inquiry was ever conducted to ascertain the residential status of the petitioner, and had such an exercise been done, it would have revealed that the petitioner is in fact a resident of the service area in question. This court finds that as per the impugned notice, the petitioner's candidature has in fact been rejected on the ground of not being a resident of the service area in question. Whether the petitioner actually belongs to the service area or not, as claimed by her, is a factual aspect which can be ascertained by the concerned authorities by making necessary inquiry if need be. Stop. The writ application is therefore disposed of, granting liberty to the petitioner to submit necessary application before the CDPO.
Opposite by number 4.
CDPO.
My lord.
Before the CDPO, ko jaga?
CDPO Bodosai.
So CDPO Bodosai, highlighting her grievance and submitting necessary proof of her regarding her residential status. On such application being submitted within the stipulated period, the CDPO shall consider the same after making an inquiry and proceed further and after making necessary inquiry and pass necessary orders. Yes.
Item number 13.
Should I pray for an adjournment?
This is matter 1 week after. This is matter next week could be.
Item number 14.
I'm petitioner. I've appeared through caveat. I'm filing an affidavit. I've already started a copy. Yesterday evening, you saw the copy.
What are you filing?
Objection, madam. I've preliminary objection is the maintainability of this need to be.
Okay.
Because of that new circular, guideline has issued against that order of the first appellate of the ADM, appeal life to the Board of Review.
Sri Samir Kumar Das, learned counsel appearing for the
Number 4.
opposite party number 4, files a preliminary counter affidavit questioning the maintainability of the writ application after serving copy on the counsel for the petitioner. Same be kept on record. Yes. Oh, this is a paperless matter.
Very substantial.
You file it in before the counter. Yes. It cannot be filed. This is a paperless matter.
Because yesterday evening only.
No, you file it. I'll just record it. I'll record it so that you can file it. Only please. Files submits that he will file.
Yesterday, it is ready, my lord, because yesterday I have received the copy, therefore evening only.
No, that's all right. That's all right. That is not an issue. But the question is because this is a
Let the matter come tomorrow or day after tomorrow.
Let me please.
this is a paperless matter.
Paperless is alright, but.
You can make your submission. You can make.
226 court.
Sir, you can make your submissions on that basis.
Then no problem.
A limited submission. Because again, my lord, the substantial question is before Lordship is that admittedly on the date of advertisement, I had given the caste and residence certificate prior to 6 months from the date of advertisement. Hence admitted 2018 certificates I have given.
Yes.
And on the date of verification, I produced the subsequent certificate, identical certificates, 18 and 2021. I submitted the 6 month certificate, within 6 month certificate of the caste and the residence certificate. Now the question for consideration, which is also pending in other cases, that whether the last date on the date of verification or the scrutiny, the certificate which is produced will be accepted, or from the date the application was made. Because the applications were made ordinarily on the photocopies or on online through online attested copies and etc. But question for consideration is the admitted fact, which was Lordship is, on the date of application, I had given 2 certificates. One is caste, another is residential of the year 2018. Advertisement was published, Annexure 1, in 21, 3/9/2021. I had given 18 certificates. And there was a clear stipulation in the advertisement, the guideline, that after the date of last application, on the next date, verification will be made, which has not been made in this particular case because of election of PPL. It was referred to 1/11/2021. On 1/11/2021, once again I submitted the certificate issued in the year 2021 itself. So very limited question, whether, because that's the admitted fact, I had not given the certificate of 6 months during the date of application on an online application, but I have admittedly on the date of scrutiny or verification, I had given the original certificate, identical certificate, only issued in the year 2021. This is the crux of the matter.
Yes. What is your preliminary objection, Mr. Das?
Kindly have this, at least, I will file it, kindly have a glance to the
Yeah,
guideline. I am not in the merit now.
What guideline?
My lord,
What guideline?
yes, kindly see page 4, annexure A/4.
Oh, that second appeal?
Recusal, yes.
That will not have to be applied to this. This is a cause of action has arisen much before.
Only I was conducting a case just 1 month back. They signed that my lord have directed to file that appeal to the.
No, that must be.
That is also a case of that day.
So it must be then.
The order was in December.
Order may have been in December.
After this order,
No,
but the
here-
guideline, my lord, what the says.
No, here what has happened is
The
cause of
order
action-
is 17/8/2024. The appellate authority passed the order.
Maybe. But the cause of action, the original order of appointment or disengagement or whatever, that must have been passed prior to this.
27/5/2022, I was appointed.
So
That was, this is my lord's order. I cannot.
no, you refer
Say-
to that. I can see that order.
That is that order. That
I
is
can
why
see
I
that
filed it. I could have filed an objection if my
No,
lord.
I don't
Very-
think this
that-
can-
but
May I
my-
submit
this
one-
court has,
This will not have retrospective
May
application.
I submit one thing
Yes.
more, my lord?
this court.
As I found, my lord, from the preliminary objection filed by the opposite party, my lord. There is a disengagement order
Yes, already says
on
been disengaged.
28/2024, which is not impugned in this case.
That
Yes.
is not, I have not received it.
Yes, sir, that he has also
So,
been
my lord,
disengaged.
one
That
of the
would have-
documents which is also required to be impugned.
No. We will go to that.
Yes.
But here, the question is whether the new guidelines will apply or not. I don't think.
Your lordship on different cases, my lord, your
Yes,
lordship has
passing order.
specifically stated that, my lord, because the appeal is prior to that 15/3/2023. So the writ will be there.
No, Mr. Das is saying that in some other case, I don't know, I may not, I could not have, I don't remember, but you
And
give
why
me the
not? I will
number.
bring that on. It
You
might
bring
not,
that on.
I tomorrow, because I am,
Yes.
I was the.
In that case, probably
I was
the
also the opposite, but not that I.
cause of action may have arisen before this guidelines came.
That was, this circular is of dated
15/3/2023.
15/3/2023.
23.
Yes.
Thus, order passed by the appellate authority in December 24,
Yeah.
23. The other person filed the appeal before, writ petition before this honorable court. State government for the first time brought this to the notice of this honorable court, and this honorable court has said and directed disposal by the, because there is an alternative remedy. That was the case, and that case has been remitted to that director. Sorry,
Do you have a number of that case right now?
right now, Waida Khatun mon nata mon achi, mu nije korthili. Airport court. Sanjay Das appellant by mu opposite party.
Why the Khatun say, I'll take why the Khatun
ମୁଁ
number?
କାଲି ଦେଖୁନ କାଲିଟା ଏଠି ତ ସେ ତ କପି ମୁଁ ତ ଫାଇଲ କରିବି ଏଠି କମ୍ ଟୁମୋର ଦେନ୍
Yes, Mr. Let it come tomorrow. Let this matter.
Sir, it everything put together. 28/8
Like, submit copy that he said that I have refused. Why shall I accept the copy? My associate should accept the copy.
ଆପଣଙ୍କ associate-
no you were refused.
To say, in open court, you are saying that I have not received, I refuse.
My associate says sorry
Back
you have refused. He told me that
Give the court master the number
again
of that previous case.
ମୁଁ
You are
order
referring.
କରିବି that file is with me.
नहीं फाइल तक देखिए पड़ेगा ना कोई cause of action arise
ମୁଁ
करছে
file ଟା ନେସ୍ କରିବି yes ମୁଁ instant line ମୁଁ ପୁଣି
This is the appeal of 2000.
No, if you give the number, we will call for the file.
yes ମୁଁ number ଟା instantly ବର୍ତ୍ତମାନ ତ ଆଣିପାରିବି
ବର୍ତ୍ତମାନ ନାହିଁ ଆଜି ଦିନ ଭିତରେ ଦିଅନ୍ତୁ ask your associate to give it to the court master.
ଆଜ୍ଞା
Okay.
Around 15.
that will be better cases will be entertained here also. It will not benefit the
I don't know, unless I go through that I will not pass any comment. Yes.
My lord, this is the matter which was parted by your lordships. After hearing myself for the second matter and learned senior counsel Mr. Buddhadev Rautray in the first matter, and the state Mr. Patnaik, your lordship thought it proper to take assistance of senior.
Yes. That reservation matter. Yes.
Lordship have, by your lordship's last order, has engaged two senior counsels in this matter to assist your lordships, and also the advocate general to assist your lordships from the side of the state.
Where is the advocate general?
Today, my lord, today we have filed one affidavit. On the last occasion also, my lord, we had stated so that on the basis of MG Energy Act, when this particular policy was taken, and this policy is also under challenge filed by my lord friend, my lord. That previously, my lord, it was a single cadre post, and later on, my lord, now district has been treated as a unit. So that is also under challenge. So why we have taken such a decision and other things? So we have clarified that in our counter affidavit, an additional affidavit matter. So we have filed it on 16/12 to. No. We have filed it on 31st August 2021. Pre-filing, my lord. So we are filing the.
So here, what has happened is the advertisement was only for reserved category candidates.
Yes.
According to you, you have taken the shortfall. You have advertised the shortfall vacancy.
Yes, ma'am.
My question was whether you could have retrospectively applied the principle of reservation when they themselves did never claim reservation, and they could not have claimed.
They could not.
They could not have.
That was a single cadre post.
So you will have to argue looking at Article 16 of the Constitution. Not only the ORV Act, but also Article ORV Act, whatever Mr. Mahanti has said that it is applicable, not applicable, that is a secondary issue. Whether this principle of reservation, it's a constitutional matter, it's a fundamental right. It is included in Part 3, isn't it? So whether it can be retrospectively applied, this is the question. But where is the other senior counsel?
See, I'm on behalf of senior advocate Prafullo Kumar Rathore, your lordship. He's out of station for the first hour.
Yeah, that's all right. I will have to adjourn it because he has filed something. You have received copy.
In fact, we had also prepared a small note for the court. And our preliminary submission, we started by examining the constitutional provision, because I think with the coming of the constitution, first reservation saw its light in Article 16 and 15. And there was this whole debate before the constitutional courts that what is the nature of those provisions. So the court, in fact, in the recent judgment also, in capturing everything, has said it was an enabling provision. So nobody can claim reservation as a fundamental right. Now, why this proposition is important is, if it is enabling provision, that means for an application to it to a state government employees, the court, the state legislature has to come up with an act, or you exercise 309 power, whatever may be. And in fact, in those judgments also it's been clarified that through executive instructions also it could have been, but there has to be some enabling power. So when you exercise such a power, you lay down the ambit of that exercise also. So in state of Odisha, in 1975, they came up with this act and they laid down the ambit. And the ambit specifically has to be seen with the definition of what is state's definition and section 3 and also section 19. So to just cite that first point, we have 2023 SEC 1, which in fact your lordships will, all the judgments are there. Your lordships will look at para.
One thing, let us agree that we are not going to conclude it today because the Advocate General is not there and Mr. Rathore is not there. When is he expected to come back?
He is expected to come back in second half, but second half there is a matter of history.
Oh, second half today? No, today we will take it up further. This will require hearing.
Both against each other, so that is.
No, this will take some time.
The only preliminary we are just trying to impress upon your lordship.
Yes.
Your lordships will see para 11. And that's been the opinion of the Supreme Court throughout.
Para 11, yes.
11. Onwards, I'll read it. The central point, now, your lordship, in fact, this judgment also occur in view of those consequential seniority, catch-up principles and everything. So, because as far as catch-up is concerned, it's not a fundamental right. They said that even reservation is not a fundamental right. So, in that light, they said that 16, because that's the source of power today.
Why do you say it's not a fundamental right? It's included in Part 3.
It may be. That's why maybe I'll just read that. Then
Please.
The The central point that arose for consideration this appeal is whether the state government is bound to make reservation in public posts and whether the decision of the state government not to provide reservation can be only on the basis of quantifiable data relating to adequacy of representation of persons belonging to scheduled class and scheduled tribe. Article 16.4 and 16.4a do not confer fundamental right to claim for reservation in promotion. By relying on the earlier judgment, this court, it has held in Arjit Singh, this Article 16.4 and 16.4a are in the nature of enabling provision. And that's very important. It's an enabling provision, vesting a discretion on the state government to consider providing reservation the circumstance so warranted. It is a settled law that the state government cannot be directed to provide reservation for appointment public. Similarly, the state is not bound to make reservation for scheduled caste, scheduled tribe matters of promotion. However, if they wish to exercise the discretion and to make provision, the state has to collect. Rest of the portion are actually not important. It's only for.
No. I had not thought of it in this way.
Yes. So if it is.
I had thought it from the citizen perspective, but it is actually, you are right. It's an enabling provision.
So that means if that particular aspect of constitution has to be given effect, the state has to come up either with a legislation or 309 or even an executive instruction. Indira Sani says that. So you have to understand in 1975, when the state government came up with this, it laid down the parameters. Now that's the legislation, it holds the field. And if it holds the field, now again, an executive instruction cannot dilute it. If 162 power cannot be there, used to dilute.
Theory of occupied field and.
Yes. So these are the fundamental principles in which we are actually looking at the matter and placing it. So when 1975, Your Lordship, this came out, may I just take Your Lordships again to the act? Over the act.
What is the act? SCST SCST manual. Third was Constitution na nahi. Constitution na kinda no. Yes.
Yes, Your Lordship. May I just show few provisions of this act? One would be Section 2 G.
2G, state.
State includes government and the legislature of the state of Odisha and all local and other authorities within the state or under the control of the state government. Now, this definition becomes very important to understand Section 3. The act shall apply to all appointments to the post and services under the state. So it was applied universally to all. But then exceptions were carved out. First exception being, which I think probably is relevant in this case, is that it will be D. Those filled by up on the basis of the contract. These are contractual posts. So per se, the legislature thought that no, we are not going to apply it to that post. So that's one thing. And then, Your Lordships, there is also another judgment which we have brought, 1998 4 SEC, which says to single post again it cannot apply.
That is.
Yes. So this was the position. And all these posts were filled up only on that position. They were filled up only on the basis of merit. That remains the whole thing.
That is exactly what I had posed it to the state.
Exactly.
You are superimposing reservation on somebody who has not claimed reservation.
Exactly.
This is the point. I don't know.
Now, Your Lordships, reservation is vis-a-vis the post. Benefit accrues to a certain class of people. But vis-a-vis the post, these posts were never covered under this act. And that remains an undisputed fact here. Continues so. Nature of the cadre changes. Somewhere in 2017, nature of the cadre changes. So now what you are asking is that to something which it had not been applied to make it applicable. But thing is, it has already been done, already been over.
Can't be undone.
Yes. And Your Lordships, we are also examining, of course, to that extent.
I gave you were not there on the last occasion. I had given an example to Mr. Mahanti and Mr. Patnaik, where I had done it, but it was a state cadre post.
Yes, that is what the
as member secretary of the State Legal Services Authority, there was a state level, cadre of called mediation clerks and mediation peons. 30 district mein. So, initially appointed what had happened, so let me not say. So when I came forward to appoint, so we had, what we did is, we took the shortfall vacancy.
Yeah.
We could do it because it was like a
yes, which is why Your Lordships must have done also in view of 12A and 12B. Now 12A says
Yes.
All appointments made in contravention of provision of this act after the commencement of the Odisha reservation or vacancy of
Yes.
post in it shall be treated as voidable. And 12B also creates a penal action of
Yes,
discipline.
yes.
So therefore, if you have to look at the whole ambit of things, at that point, this was not applicable. So all appointments were valid in law. This kind of a consequence was not to follow. So if you are today saying, no, we'll apply this, then you're almost trying to say that I am taking back this act to that day with along all these consequences. So are you going to say that are they voidable? It does not fit in terms of law. Then we also came across a particular judgment from Jharkhand High Court. Now this comes in view of these amendments which have come, EWs, where the advertisement was floated and the court has said, no, you will not apply this retrospectively. What the reason, fundamental reason, it's always enabling. As and when it comes. And you cannot do something the statute has not permitted you to do. You cannot take those posts as they existed. Yes, the entire cadre is always the strength.
You see, because whether to claim reservation or not can be an individual decision or preference. There have been officers, at least I know presently, a very senior IAS officer. He is a reserved category candidate, but he chose to appear only on merit and he got selected. He never claimed reservation. Now to tell him that you belong to such and such category, social category, so you will be treated as such as a candidate, I don't think this will hold much water.
I was not able to, of course, gather those constitutional debates. But if I remember very clearly, of course, as a student, I remember that. When the issue of reservation did come up before our Constitution Assembly, nobody wanted a class reservation. We are not allocating posts to them. Then what will happen that 50% should only for the Brahmins or the corridors or whatever. And we have not done that. So again, it takes us back to the Savarwal case also, which says no, the unreserved category means it's open to all.
That is open to all.
All. So now what was open to all, you are going to impose an identity on them. That's not something which a constitution ever.
And how do we know that they belong to this particular category?
Exactly. That means that means people who as such were under the unreserved category, it was not subject matter of reservation at all. Now you are making a profiling of them. So you are actually saying that caste is an important profiling. That kind of identity you cannot impose on them. Because reservation for scheduled caste and scheduled tribe was because there was a historical deprivation from the socio-economic cultural rights. So you're putting them there by not allowing others to participate in a particular post, but allowing them to be treated as general. So therefore, there's a very balance between not to create an identity, yet enable them. If we do the social profiling, I think it will be a violation of Article 14 and 15. Maybe that argument has to be put a little more.
At least Article 14 though will definitely come into picture.
A little more we have to, maybe I'll have to pull up those constitutional debates. So I would, for the prime.
Yes.
Primarily, this is what we wanted to say today.
Yes.
And, Your Lordships, in fact, in one of my own judgments also, before this court has been also confirmed in Supreme Court, there was a little debate on that contractual post. Of course, so there the court has clearly held that if you look at even Section 19, the Supreme Court orders there, Section 19, that no instructions or any kind can overcome these provisions. So even this present instructions are actually going against Section 3. You, at best, what you can do is consider all of them general. And then rest of the post, you do what you would want to do.
But my prima facie view, and I'm repeatedly saying that this is not my final view. It may be the final view, it may not be the final view. Judge always has that prerogative to say so. Anyway, thing is, once you make it up a district cadre, then it operates prospectively.
Yes.
Then it cannot go back.
Yes, ma'am.
If you go back, then it will, as she has rightly pointed out, that going back itself will offend the provision under Article 14 as well as Article 16.
15 also,
15.
15.3, because they are now categorizing them on the basis of their birthmark, because they belong to that category, now they have been taken into that category also.
Originally also, your lordship will see, it was not really available, it was very much not available also in an enabling provision. It was available in a very negative way, in the sense that it does not prevent the state from creating special circumstances. It was never for making a social profiling.
No, 15 and 16 are what? They are exceptions to Article 14. One may say that, in a way.
Say that, no, actually, I think this is a little different over there. I mean, there's a very nice picture in which circulates among the legal world, that if you have one boundary wall, and you have people of 3-4 heights, so not everybody can see. So the one who is above, say, 5 feet can see if he's 6 feet tall. And the ones who can't say has to be given a chair. So that's the analysis, that we are all treating you equal, but because your circumstances have been different, so we are giving you specialty to come to that merit level.
Level playing field.
Yes. So they do say, when you're making the special measures, you are definitely enhancing the whole Article 14. But when you are forcing an identity of them, then I don't think it is, because they've got it on the merit. Then you are actually hurting the self-worth.
You are, in fact. So
nobody wants to be in clutches forever.
Yes. All right then. So what is it that you are filing today?
Today, my lord, we filed an affidavit indicating why actually it was necessary to bring that particular reservation law in respect of these particular portions, and how your lordship had specifically put me a question on the last occasion, previous occasion, my lord, that how we could reach to a conclusion with respect to the persons who are already existing in the cadre about their social status. So these are the two questions which was actually put.
How do you propose to answer them? How have you answered them?
My lord, prior to this, my lord, in fact, there was a provision which was available for the GRS to get inducted into the Panchayat Raj department, such as the PO post, and PO, to get into the one of the state civil post, my lord, that is PO, Panchayat Executive Officer. For that reason, there is a provision, there is a percentage of reservation which is available for them for consideration. So for considering them against that particular quota.
From their applications, you came to know. Since they applied for that?
No. We prepared a database throughout the state. We prepared a database and on the basis of the information supporting with the documents, whatever, in support of their social status, when they provided to us. Thereafter, we prepared the database and prepared the entire list, the list of the total eligible persons, and we utilize the same at the time of considering their cases in the subsequent while considering their case for the civil post.
No, as Ms. Rotha has pointed out, supposing somebody belongs to a scheduled caste category,
yes, ma'am,
but he says that I don't want his reservation. Can you force him?
We'll consider him as a.
But here, what you have done is
no. That the person who has claimed that he is belonging to the scheduled caste category, only his name has been reflected as scheduled caste category.
No, let him claim that I am scheduled caste category, but I don't want any reservation. Supposing it is open to him to say so.
Yes, my lord.
It is open to him to say so. Because that is exactly what has happened. He has joined not as a reserved category candidate.
Whenever we have to prepare this list, my lord, and then we are bound, my lord, whatever the information is provided to us, we have to reflect it. Now it is for the person concerned to take a decision that whether he will avail that particular reservation or not.
But then the other question remains, yes, whether you can retrospectively do it.
We have, my lord, our answer that, my lord, we have not retrospectively done it. Because why we have tried to clarify that in this way, my lord, that it is not that at the time of taking into consideration the status of the vacancies which are now presently available after declaring it as a district cadre. Now, my lord, the reservation law, it is not for the first time which came into picture for the GRS. Because this post, which is actually floated, my lord, under a scheme, it is actually under the creation of the MG Energy Act, my lord. There, the Act itself stipulates that the posts which are to be filled up following the reservation law. So, my lord, because it is a single post, so the law of reservation had no application to the case. Now, since we have decided in the year 2017, my lord, that district as a unit. So at that particular point of time, we took into consideration the number of the vacancy or the number of the posts which are available within the district. Now calculating that particular number as a unit, district as a unit, then we decided the total shortfall, my lord. And that is what it has been decided in a example set, my lord, in our case, overall case also.
Here there is a deeming fiction. You have treated them as if they were, their caste may be such and such,
Yes.
but you have treated them as if they were
My lord, the
appointed as reserved category.
The database we had prepared in the year 2013.
Maybe whatever.
Now
That,
the
that
dissolution
database is an administrative action. That is an administrative action.
Yeah.
For your, in your routine way, you are maintaining that. We are not interested in that.
Yes, ma'am.
But to treat them as reserved category candidates, even though they were not appointed as reserved category candidates, is as applying a fiction.
Now, my lord, the question that, my lord, if I put a question to myself, my lord, that a person belonging to the social status, having belong to a reserved category, he compete the same on merit. My lord, now once he is inducted to the same cadre, then in that case, my lord, whether his right for consideration against the promotional post in future, as against the reserved category post, shall be taken away from him, my lord. Because
because at that time for promotion,
yes,
the consideration is separate.
so my lord, his case is to be considered, irrespective of the fact.
I was hearing. I think we were hearing a matter of that OUAT, where he was wrongly treated as a
SC or ST.
candidate.
Yes.
The promotion, when there's a question of promotion, the consideration begins anew.
I could not properly place it before.
Anyway, let the Advocate General appear.
Savarwal case, para 5 and 6 has to be read also carefully. Savarwal case says that if you are deciding to apply, because you have to apply to the entire cadre, not to vacancy, to all the posts, you prepare a roster then. Earmark everything. So all these people actually will go into general category, because if what they are saying you are trying to do, then you are actually reducing the chance of SC/ST to get. You are going to fit in them on the basis of their identity and forcing them to be in their SC/ST quota, whereas more would come if their identity is not forced on them. So people will be there in general and then they'll go. And promotion quota, a very simple, what happens in promotion? It's as far as SC/ST are concerned, they only get accelerated promotion. But suppose they're in reserved category, that does not mean they don't get promotion. They get promotion in the usual, and so many people get promotion. I mean, from people who are there in the general category, but belonging to, have a social status of SC/ST. So thereby you are actually reducing the, chance of more SC/ST to people to come in. Which SC/ST actually have to come? No? Ideally, are not getting in their merit.
Anyway, so we let us keep it to some other day.
But all these things are simply misconceived for the simple reason that the guideline by which they got the opportunity to apply reservation
did not have any inter-reservation.
That itself says it is prospective. Your Lordship, kindly come to running page 26. Only one page.
Of which?
Well, the second brief where my lord in writ petition number 131/7 of 2018.
13017.
Yes, madam. Which is as per your Lordship's previous order, it's the lead case. Your Lordship may kindly see
that comprehensive guidelines. Yes.
Yes, page 26 straight away.
Yes.
Last line. This guideline supersedes all previous instruction and is given effect to immediately. That means while issuing this guideline, they themselves have said that this guideline is prospective in application. Even if they took a decision that ORB Act will be applied for recruitments, so that cannot be made retrospective under any circumstances, maybe directly, maybe indirectly. Whatever now they are doing is indirectly applying or extending the applicability of this instruction to all those appointments which took place prior to coming into force of this guideline, which is impermissible.
All right. As requested, Ms. Famirath, Learned Senior Counsel, is present in the court. Therefore, adjournment is made on behalf of the other Senior Counsel, Mr. P.K. Ratha, on the ground of his non-availability.
Myself is appearing in fact of the opposite parties.
Sir, petitioner. So far the state is concerned, they are filing an application copy with the copy.
Yes, yes. When State Council files, you are filing an affidavit, Mr. Patnaik?
Yes, well, today, my lord,
Yes.
we have already filed it to.
Or you give copies to everybody?
Yes, ma'am. We'll-
When State Council files an affidavit, which is taken on record, let copies thereof be served upon counsel appearing for the other side. Yes, when will the Advocate General come?
Third week of September.
Third week of September. All right, we'll adjourn it to that date. Let us agree upon a date.
My lord,
Madam, upon violation data.
Third week, 23rd. We'll take it up on 23rd September.
Yes, ma'am.
The State Council further requests that the Learned Advocate General
24th, let it be 20.
All right. Learned Advocate General may not be available in the near future, and requests for listing the case in the third week of September. आगा first लिख दो तू. अच्छा था उसे लिख दो. List this matter on 24th September as a part-heard matter.
My lord, the matter 13107 is directed to be the lead case because all these pleas have been raised in my case, not in the other.
I'll pass order in that case. Don't worry.
No, my lord, I'm not saying, my lord, because of your lordship's order, I am told, my lord, brief of my case has not been supplied to any of the learned senior counsels.
Okay.
So only the first matter brief, it has been,
Okay.
that is why, my lord, the office is at.
नहीं हमारा order कला लोगों से नथियो.
সেটা নাই তো সেটা দেখছি.
On consent of the parties, it is directed that WPC number 13017 of 2018 shall be treated as the lead matter. Let copies of the writ application be supplied to the senior counsel appearing on the request of the court. That's all.
Okay.
Formulate point according to the
হয়ে যাচ্ছে সেটা রেফারেন্স হয়ে যাচ্ছে.
সেটা কোন হইছি সেটা অর্ডারটা 2 সবুথর পাই অর্ডারটা 29309 রে পাশে গলা.
হ্যাঁ হ্যাঁ স্যার এটা এই স্যার দেখুন.
But the question is, Mr. Rautre, the question is whether the principle of reservation can be applied retrospectively to the existing employees who did not secure employment on the basis of reservation. This is the question.
Oble.
Further, is it open to the authorities to apply the principle of reservation by simply considering the social categories to which the existing employees belong? The word these occurring.
It is a very wide and vast subject, right from 93 Supreme Court, Indra Sani's case, 16-4 and all these things.
Because the whole idea is to apply reservation to the post, not to the people. People will get the benefit.
Yeah, but from what you know, this will have a long journey also.
And it's an interesting question also.
Yes, yes. You need to have a long. But I make no bones about my prima facie view. I made it very clear from the very beginning itself. So I don't know whether and this retrospectivity principle which you are applying. Had Mr. Patnaik been on this side, he would have argued differently, I'm sure.
Yes.
He jumped over to that side, so naturally. But please request the Advocate General to appear.
Yes, ma'am.
Because this is concerning the entire state.
Yes.
So this is a very important point. So
Because this will definitely see its face even in Supreme Court. Because this is a very, very vital thing. A very vital issue actually.
Mr. Rata, after I pass, I become functus officio.
Point of law.
Yes, yes. This will go. Anyway, the word these, DHEAC, occurring in paragraph 2, in the second last line of paragraph 2 of order dated 6/8/2024, be corrected as the, THE. Hello? Yes, sir. Item 16, pass over.
Not 17.
Pass over.
But a cause of action doesn't survive in both the cases, 16 and 17.
No, I was just passing it over.
Sir.
Item 18.
Mm-hmm.
19.
Hmm.
Item number 20. Item 21. Item 22.
Final item 22. I am today appearing for the opinion number 3. I will file counter in it.
Let the petitioner first appear. 2013 matter. If he doesn't appear, I am not going to keep it pending.
Pursuant to my your lordship,
Sir, I may have said, but if he doesn't appear, what will I do? I'll not keep it pending.
On 22/7/2024, I was included as OP number 3. Pursuant to notice, today is my appearance.
You are filing counter.
5 କରିବି 7 ଦିନ ଭିତରେ।
How देखिए पास आउट जाओ तब जदि काय अपेयर कर जियो
ସେ ଆସିଲେ କରିବ ଯଦି କରିବ।
आसुन
Item 23.
23, I am petitioning the second case. Let's say, can I pray for next week?
2013 matter, Mr. Mahanti. All right, next week is prayed for.
Only next.
All right. Mr. Mishra,
My lord,
briefly, he showed his face.
my
Yes.
lord, my lord. My lord,
A very brief appearance, like
No,
like
but,
appearance.
I got disconnected, my lord.
Disconnected by manually or automatically?
ଏଠି ଭୁଲ ହାତ ମାରିଦେଲି ଟିକେ
ସେଇଟା ତ କହୁଛି କଥା ଆଉ ହାତ ନ ମାରିଲେ ବର୍ତ୍ତମାନ ଭୁଲଟା ବି ଚାଲିବ। Anyway, it will come next week.
My lord, because appearing in your
I won't grant further adjournment. This is a 2013 matter.
my lord, in fact appearing in your lordship's court through virtual mode is little terrifying, so therefore
Terrifying for whom? That is to be seen.
because your lordship doesn't prefer that when therefore.
Yes, 24. Huh? 24 adjourn है जी।
My lord, in this case, the case of the petitioner is that the petitioner was engaged as a Yogana Sahaka under annexure 4. He has been appointed as per the government guideline issued by the Commissioner cum Secretary, OP number 2 under annexure 3. And as per the guideline, as per the approval of the collector, his appointment order was issued by the Sarpanch under annexure 4. He was disengaged by the Sarpanch without following the due procedure of law. So he made a representation before the collector, before the BDO, OP number 4. During the pending of the representation, the petition approved this honorable court by the annexure 7. This honorable court was free to direct the OP number 7 to consider the representation of the petitioner. That order was not implemented, so he filed a content petition by the annexure 8 and annexure 9. The BDO has rejected the representation of the petitioner. Against that order, I have approved this honorable court.
My lord, in this case, my lord, we have received a paravage comment. But no, if we have not filed a counter, my lord, may short adjournment may be given so that I can file a counter.
Learned State Council requests for a short adjournment to file counter.
Yes.
Please this matter. On 23rd September, counter be filed in the meantime. Positively.
Yes.
56.
In this case, the intervention petition.
Who's for the petitioner? You are the petitioner?
No.
No, that is what I'm asking. Who's for the petitioner? Let us pass it over. Pass over.
57.
Yeah, pass over.
8.
Sir, I'm supposed to file a amendment application. It is ready. I could not make the affidavit 2-3 days time.
As requested by Learned State Learned Council for the petitioner, let's this matter next week. Yes. It will come next week, Monday, next Monday. Yes.
Item 29.
28.
28, I am the appellant. No, 29 will give up. Move 28.
Item 29, the petitioner government.
Item 29, you are the petitioner?
I am the petitioner.
Yeah, Monomoy was to
Yeah,
My lord, 28, my lord, sir. 28, my lord, so I am for the respondent. You permitted to.
No, he wants some time to file a amendment application, so it will come next week.
28.
Item 28.
No, my lord, 28 is second appeal.
No, that is a weekly list. We are on the weekly daily now.
All right, I'm sorry.
That's the confusion. My learned friend also confused. Mr.
Kind confusion, kind?
He came and said, I am in the 28. So heading is there, weekly list.
Yes.
Nobody is willing to see either we are catching the edge. That's the problem.
Yes.
My lord, in item now 29, my lord.
I am the petitioner.
My lord, today we are filing the counter, my lord. Within the course of the day, my lord, I will file the counter.
Last time also you had taken time to file.
Actually, annexure 1, my lord, what I beg to submit, my lord, annexure C by 1, yes, C by 3, my lord. there, my lord, we have actually annexed a copy of the allegation petition. Now, my lord, instead of enclosing the allegation petition of September 2023, we had annexed that 11/2023, November 2023. So we have collected that one. Today, my lord, in the course of the day.
Sri Patak learned AGA submits that undertakes to file the counter affidavit in course of the day.
In the course of the day.
List this matter. Then let a copy of the counter be served upon the counsel for the other side. List this matter next week.
The interim will continue.
Interim order to continue. Item 30.
And this is item number 30. We have prepared the counter, my lord, and submitted the same, my lord, through e-filing, my lord, on 23rd August. Hard copy or
London State Council files hard copy of the counter in court, which was e-filed earlier.
Yes.
Same be kept on record. Okay. Yes. You have received the copy of the counter. Ready?
Actual dispute. Actually, they have done not disputed. Then I give a short date for that. So that.
This is better next week.
Okay.
31.
Previous area entry motor to continue. 31. Pass over. 32, sorry. 31. 32.
32. Item 32 and 33. So Lordship may kindly remember that the whenever stay was operating, the London Judge Appellate Court Kotak has disposed of the.
This case has been already been disposed of by the London Family Judge Kotak.
She had submitted, we had called for a report. She said that applying the principles of Asian resurfacing.
In this year, by that time it was reviewed. By that time the case was disposed of. It was.
No, but I have taken note of it.
Yes.
You can proceed against that officer. Call Labho.
But I will satisfy to you, Lordship. Your Lordship may keep it to next week or 1 week after. I will satisfy. Whenever stay was operating, then it will come to say, get it back to the previous position.
Yeah, more judgment. More judgment. Restoration of status quo ante.
So it will.
It's a nullity.
Yes. So the judgment will go and it will be sent back to.
But for that, can this court pass that out? Yes, I think. I think because this court had granted stay.
Yes.
You can ignore it. So you want to cite those judgments?
Pass that order. It is not necessary.
No, we have to refer to those judgments and we have to pass a complete judgment.
Yes.
Whether we allow the transfer application or not is another matter. But on this point, the judgment will be ignored. Why don't you get ready? Kali Pardor Vitar Sardava to Rakhi. As requested by Sri Mahapatra and counsel for the petitioner, is this matter next week?
14th.
Next week though. Next week jaha bo. No padiyo. No padiyo.
Diploma.
Item 35.
Pass over. Pass over.
Item 36.
This is from impossible. Mediation is going on, man. Next date is posted on
Item 36.
Minor.
Mediation is going on. When is the next date?
Chapter.
Upon support Mr. Ponda. Chapter
Okay.
It is stated at the bar that the next date of mediation proceeding is fixed to 4th of this month. As well as this matter, good date kar de. Out here, 17th September.
Item 37.
I'm the opposite party. 37, 37.
Yes. I am the petitioner in item number 37. And the petitioner filed a 13-1 application for decree of divorce. And some of the opposite parties of that petition filed the next item for transfer. But they are wrongly added as parties in the divorce petition and the petitioner wants to delete their names. So I pray for 2 weeks time and after that, Lordship will consider my application.
No, in the meantime, is there any chance of settlement? I can send it to mediation. You are agreeable. What do you say?
I have to take instruction because for last 5 years he is not appearing in spite of sufficiency of notice.
You'll list this matter day after tomorrow. The parties shall apprise the court whether the matter can be attempted to be settled through mediation.
I have a request to let the matter come to communal place, Kottaka has data matter, Kottaka has will teach.
They said, if whatever you can, 37 times, day after tomorrow, so in the meantime, you obtain instruction from your client, both either for mediation or that there is a suggestion that both the matters will be taken up at court. If both of you agree, I can pass that on.
Here, husband rose in the bone sorry.
It will be convenient for him to come to Kotak rather than Attagoda. You take instruction. I'm not forcing you, take instruction. Yes.
39.
Thank you, Your Lordship. And the wife is the petitioner and the father.
Notice, he appeared kar nathi. Nobody is appeared despite notice. You're given a lot of time. Notice was served, nahi? And counsel for the petitioner is present. None appears for the opposite party. The office note indicates that notice on the opposite party was served long back. Matter, but nobody has appeared for him. Counsel petition allow kar do. Allow.
Oh.
40.
Lord, I'll take time for
Last
two.
occasion, your lordship directed petitioner to take instruction whether the
Matter can be settled.
expert order has been passed.
Oh, my lordship.
Oh, that application has been the case is already. Yes, what happened to that expiry decree?
My lordship, they are not appearing, Lord, in the case.
Notice has been.
Yes, my lord. Notice has been issued. And track report says they refused.
Today,
my lord. Today the case is there.
ଯଦି refuse ହେଲା ତାହେଲେ ତ sufficient ହେଲା.
Yes, my lord. That's why that the case is today for hearing.
Yes.
Yes, my lord.
Sri P. Naik, learned counsel for the petitioner submits that the application for setting aside the ex parte order is posted for hearing before the court below today.
Yes, my lord. On the question of limitation.
Yes,
my lord.
it's posted for today.
Yes.
Hence, list this matter next week.
Yes.
You can come forward with some news.
2 weeks, my lord.
अच्छा होता पर week टा करो. 17th September.
Yes.
Item 41.
41.
The matter was referred to the mediation.
Yes.
The report para children's.
This is ପୁରୁଣାଟା 25/6 କୁ ଥିଲା ଆଉ further ତାପରେ କଣ ହେଇଛି କିଛି ଆସିନି.
The report may carry forward.
Mediation report, status of mediation be obtained. Status of mediation be obtained from the mediator. List this matter next week.
42.
The interim is there. That one.
Tomorrow to continue.
But I have been given instructions to appear for the opposite party. And Lordship permits, I may be allowed to file the wakalatnama.
Please, file it. Yeah. It a court file out. Take court file you.
If my lord may permit me some time, I'll take instructions in the matter.
Yeah, just. Sri Bibhu Prasad Tripathi, advocate and associates have entered appearance for the opposite party by filing wakalatnama in court. The same be accepted. Their notes be reflected in the cost title. Now, any chance of settlement, Mr. Jali?
My lord, there is chances.
What do you say?
I'll have to take instructions, Lordship, if Lordship may allow me some.
I'll call it day after tomorrow. You take instructions telephonically. Let this matter day after tomorrow, when the parties shall apprise the court, shall obtain necessary instructions from their respective clients as to if there is any possibility of the matter being settled through the process of mediation.
Well, grateful, Your Lordship.
Item 43.
On behalf of Mr. Mahapatra, can you take it on next week?
Next week as scheduled for. से यार तारे interim order to consider करते हैं.
Item 44.
Wait, please, Your Lordship. This is a criminal appeal on a special act matter. For bail.
Under which act?
Special act, SCST act.
मतलब bail.
Right. Offences are under section 436, 307, 302, 326 of IPC and section 3 of SCST.
436 and 307. 436.
307, 302 is also there, 326.
My God, you have the case diary?
Yes, case diary is there.
Have you?
Trial is going on. Lordship, out of
25 witnesses.
25 witnesses, 10 witnesses has been examined. The person who have last seen is relative that the present petitioner is going on after setting fire, but they have never said anything. But the mother is the injured witness of the deceased. She has not been examined.
She examined who?
Mother, Chanchala Behera. She is the injured, 30% burn injury she has also received. And
She's the best person to depose then.
Yes. And she has also deposed the dying declaration also recorded in respect of her. She has not been deposed.
So, Jao.
Other two relatives who have seen the petitioner.
Sardava ji.
I was earlier before your lordship directed to expedite the trial.
चलते हैं उसे trial court से expedite court ना कौन कहीं कितना कौन
In view of that dying declaration is also rejected.
हेला High Court गोटे पर गोटे माडा कोले से बिचारा अफसर करिए कौन
The immediate witnesses those
dying declaration अच्छी mother is a injured witness
Best witness injured,
Best
50% burn injury.
let her be examined. If she does not support the prosecution you may have a case
Yes.
for at least interim bail.
Yes.
तो वर्तमान जाए होगा ना तो आपण जा करिए
now I consider for interim bail.
436 I am very strict about it.
302,
You see 436 even if it does not cause harm to the body, still it is a sessions offense. Why was it treated as a sessions offense? I don't know what is the corresponding provision in the new act. I don't know. Why? Because of the at that point of time when people were having all thatched houses. So a house is something a person, treasures. So that if you set fire, and here there's in addition to that there's murder.
Murder.
So
307 is there.
As it is born from the 161 statement of the injured my lord,
Hmm.
she has also not seen the present appellant my lord. She states that
the petition for the application for bail was earlier rejected on merits by this court on 24/11/2022 in CRLA number 533 of 2022. Except for submitting that the trial has been delayed, no further circumstance has been put forth on behalf of the appellant to reconsider the application for bail. Please ask them. It is stated at the bar that trial is in progress with 10 out of 25 witnesses being already examined. Furthermore, one of the star witnesses of the prosecution, namely mother of the deceased,
Chanchala Behera,
is yet to be examined. Taking into consideration all these facts, I am not inclined to allow the prayer for bail. Stop the criminal appeal is therefore rejected. It shall be open to the appellant to renew his prayer after examination of Chanchala Behera with the mother of the deceased, bracketed Chanchala Behera. Yes.
45.
Please, Your Lordship. In this matter, there is a noting that the Lordships were kind enough to grant an interim bail of 1 week during Christmas to the petitioner. But the petitioner could not avail it since he was subsequently taken in custody by the Kerala police. The order of bail we have annexed, Your Lordship.
Order was?
The He was subsequently taken in custody by the Kerala police. So he
In
could not
connection with
avail-
another case.
Kerala Chaltala. We have got a bail order in that case. After
Hmm.
that, subsequently, we have filed an interim bail application before your lordships.
No. So he did not avail of that. So that order still stands.
Stands, but the order specifically says that it's 1 week in lieu of Christmas, your lordships.
Okay.
Though is
I
a
may
Christian,
draw
your
the-
lordship observed.
Okay.
I may draw your lordship's attention to that order. We have annexed it. It's at page 13 of the IA.
As also on the ground of attending Christmas. But that was in 2023 December.
2023.
We are nearing now 2024 December. So what is the matter?
Yet another IA has been filed.
Another IA.
That's all.
So
Another IA number?
Your lordships had heard this matter in length. This is a matter pertaining to 406, 420, 467, 471, 120B. This is a matter, the petitioner's company, Sambat Finserv, was accused of financial fraud, lordships, in the FIR by Annapurna Finance. It was a case where it is an NBFC and it had taken loan from several companies for micro lending. Accused in although the FIR does not name anyone as such, but during the investigation, everybody else was skipped. And in fact, the interveners in this matter, our case before the trial court is also that they should have been treated as an accused in this matter, because they have in fact, your lordships, one of the grounds that we've taken in this bail application is also that subsequently, after this loan was availed
No, but you are arguing on merits. You have filed an application for interim bail, but you are arguing on merit.
An interim bail ground is lordship that he has been in custody for more than 2.5 years now.
Yes.
no, in respect of her daughter's illness, my lord, he has filed. And another 7 number of cases has been pending in various states, my lord, including
He is in bail,
Delhi
out on
and
bail in all the cases.
CBI cases and.
My lord, I am appearing for the intervener, my lord.
Yes.
My lord, this is one of those cases, my lord, where your lordships have passed a detailed order, my lord, in relation to a lady, Amrita Kindo, my lord. This is brought to that extent of 100 crores involved, my lord. My lord, the accused was granted by a bail by the Kerala court on account of non-filing of charge sheet, which is what my learned friend has enclosed in the bail petition, my lord. So what he is seeking of interim bail, I am not in the way, my lord. It's your lordship's discretion, my lord. If he has to argue on the merits, my lord, I'll press for objections, my lord.
No, I would like to know on what ground you are asking for interim bail.
Only on the ground of the daughter's and wife's illness, both your lordships.
I have to take instruction on that respect.
Yeah, obviously.
See page 11, annexure 1, your lordships. And this is long suffering. We've been annexing their prescriptions. As a matter of fact, the father of the petitioner and mother of the petitioner both are dead. The wife and daughter are the sole surviving members of the family now. The wife is not able to earn bread because of her history of arrest. Wife has neuro problems that has been there for.
Have you enclosed any copy of the medical reports? Then you take instruction.
Page 11 and 12.
Then let the state take
I have to
instruction.
take instruction, my lord.
London State Council shall take instructions with regard to the medical documents enclosed to the IA. Does this matter? Huh? On 23rd September.
Much of it.
Item 46.
Correction कर दूँ थे ना? Correction be made accordingly. Yes.
47.
748, your lordship call for the CD. In fact, today he is sending, so I pray any other day next week. CD is
As requested by London State Council, is this matter next week?
49.
Please, your lordship. 49 item and order dated 12/2024. The alleged offences, my lord, 52 Excise Act. But the order passed, my lord, the matter is taken up by I-1. Learned counsel for the petition permitted to impute the informant as opposite party number 2 in the case. Issue notice to the newly added opposite party number 2.
Is it कितने matter? 49. 1084 of 2024. What order was passed? You are saying? As per official note, the word BLP. Bullet है जीच में
Yes.
कौन order pass
Order,
That 52 Excise Act.
Well, I'll withdraw. I'll recall it and pass a fresh order today.
It has been revoked, my lord. I think I have seen the net.
No, I think तापर आउट किसी order pass नहीं.
ତାପରେ ସେଟା ମୁଁ ରିକ୍ୱିଜିଟ୍ ଫାଇଲ କରିପାରିଲିନି ଡିସମିସ୍ ହେଇଗଲା ତାପରେ ପୁଣି ସିଆରଏଲଏମ ରେ ଫାଇଲ କରିକି
CRL में allow होला.
ସିଆରଏଲଏମ
तापरे
ସେ ମଡିଫିକେସନ ଟା ପରେ ଅଛି ପର୍ପୋଜ ସେ ମଡିଫିକେସନ ସେ ଯୋଉ ଆଇଟା
कौन modification?
ଅର୍ଡର ଡେଟେड 12/2/2024
12/2/2024. There is no such order. Okay. এইটা হওয়ার কথা নয়. So bail was granted.
ଅର୍ଡର ବେଲ ଆଉ କଣ ଏଇଟା ହି
Well, ହେଇପାରିନି ଏଇ ଅର୍ଡରଟା
ଏଇ ଅର୍ଡରଟା ରହିଲା ତାପରେ ଆଉ ହେଇପାରିନି କିନ୍ତୁ ଷ୍ଟାଟସ ରିପୋର୍ଟ ଡିସ୍ପୋଜର ଦେଖଉଛି.
Now what do you want? Anyway, that has been restored. Then what do you want now?
এই অর্ডারটা ফর মডিফিকেশন মেথড এথিরা অপোজিট পার্টি নম্বর 2 কে তো only state is the opposite party offense মেথড 52 excise.
All right, considering the submissions, order dated 12/2/2024 is recalled as the same was inadvertently passed. Heard on the anticipatory bail application afresh. तब जा करेगा तो कर दो. जा हुए order टा से आपो.
50 मेथड one of the co-accused has granted bail in ABLPL to 214/2024 atomic plus 910 offense measured with 52 excise.
Similar.
Yes.
So item number 3.
The present petition before my lord is the wife. She has filed the application for transfer of the case of the Court of London, Family Court, Bhubaneswar, to the Court of Khordha, mainly on the ground of maintainability, my lord. And may kindly have a glance.
Maintainability I cannot consider.
No, I want to show the things before my lord. Kindly have a glance to page 7, my lord. The cost title, the cost title, the present opposite party address has been shown to be Dihogaon, Post Narendrapur, PS Ranapur, District Noyagarh, my lord. And the present opposite party of the court below, petition court, has been shown to be Khordha. So either my humble submission, either at the Khordha or Noyagarh court, family court is the competent court. And although there is absolute no averment in the particular petition of divorce filed by the husband of the party, that she at least is staying in the particular area or showing any document to that, this petition is not maintainable.
Notice, stay. 20 कितने? 28th October.
So item number 4.
My lord, may take this matter next week. For the
Next
region matter, I have made the file in my table.
Next week I spread for.
So item number 6.
Page my lord. My lord, here on behalf of Mr. Swine.
Yes.
My lord, here my prayer is for to transfer the civil proceeding, that is CS number 283 of 22 from the Court of Law and Civil Judge Khordha to Civil Judge Odonga, Noyagarh. Because the dispute between the mother-in-law and the wife,
All right,
the
notice.
daughter-in-law.
All right, notice. 28th October.
Further proceed.
किमते अपन फाइल करना था ये?
Yes, oblige.
So item number 9.
Petitioner has been appointed as a Gan Sathi and till 2013, from 2013 to till date, opposite party would vote to it not engaging in him any work. And again, petitioner already filed a writ petition, and in this matter, Lordship directed to pass reasonable order. Director, he also filed an contempt matter, contempt that also disposed of, but till date, petitioner not engaged in Gansati.
Yes. Take instruction will dispose of. Let it come 1 week after.
Yes.
Yeah, then State Council shall take instructions as to why the petitioner have they rejected your representation?
No, pending.
That is still pending.
Pending जदि अच्छी कहीं के वो देखो रखिए कहीं. The limited
Maybe
grievance of the
Annex 10,
petition.
my lord.
Yes, yes.
Annex
The
10.
limited grievance of the petitioner is that though he was appointed as Gasathi way back on Kebe.
Also 5/10/2013.
5/10/2013, he has not been given any work so far. She had approached this court. No, she has submitted a representation addressed to the PDDRDA Ganjam in this regard on 13/6/2024. It is submitted that no action has been taken on such representation even till date. Such being the case, the writ application is disposed of, directing the PDDRDA Ganjam to dispose of the representation of the petitioner, if not already disposed of in the meantime, within 2 weeks from today. Within 2 weeks, personal hearing is necessary? I don't think necessary.
I don't think so.
Within 2 weeks from today, order intimation to the petitioner. Yes.
I think, my lord, the date of engagement is 13/12/2013.
13/12/2013.
Because it is indicated in the list of dates.
13/12/2013. Yes.
As per item number 11.
A press advertisement has been issued cancelling the earlier advertisement. Lordship kindly have a glance to page 19, annexure 6 for Anganwadi worker. An advertisement was issued in the year 2007-2023 for appointment of Anganwadi worker in Surukuna Anganwadi Center. Surukuna Anganwadi Center. Me along with other applicants are there. In the Mahila Sabha, the present person along with another were present, but no decision has been taken. In the meanwhile, in clear violation of the guidelines prescribes only 7 days objection was to be called for. But on 25/6/2024, near about 1 year, a 7-day objection was called for. And nobody has submitted any objection. And also the CDPO has sought for some clarification from the state government regarding the engagement of Anganwadi. No clarification has also been received from the state government. But now the order under annexure 6 was passed on 9/8/2024. There.
So the earlier advertisement was cancelled?
No, this advertisement. This is the advertisement. From 2027 to 2028 is continuing. He is taking steps to cancel the advertisement.
First advertisement was in 2023.
This is the only advertisement, 2023. Pursuant to that advertisement,
Which is annexure 1.
My lord.
Annexure 1 is 22/2023. Then what happened?
We submitted our application.
Yes.
Your lordship kindly see.
That I've seen.
Yes, yes. Then annexure 5 on 25/6/2024.
Another advertisement was issued.
First 2 lines कहउचंती 10/8/2000 तारीख दिन कमिटीर सभ्य सभ्यांक द्वारा जांच कराए निम्न मते थिबार देखागला. These persons, present person along with was present. सरस्वती हेम्ब्रम and द्रौपदी सोरेन were present. निम्न वर्णित प्रार्थी मान प्रमाण पत्र संबंधी सचेंस कौन सी आपत्ति अभियोग थिले उक्त विज्ञापन प्रकाशन 7 दिन 1/7/2024. This was published in July 2023. Here, my 7-day objection was called for on 25/6/2024. And also, a clarification was sought from the state government. The letter also indicates, page 20, स्पष्टीकरण निमंते महिला शिशु विभाग अधिकार अतिरिक्त सचिव पत्र 7/9/2000 तारीख मध्य निवेदन करा जायतिला. मात्र तार अद्यावधि कौन स्पष्टीकरण प्राप्त होई नाही. ତେଣୁ ଉପରୋକ୍ତ ସମସ୍ତ ତଥ୍ୟକୁ ଦୃଷ୍ଟିରେ ରଖି କେବଳ ସୁରୁପଣା ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର କର୍ମୀ ପଦରେ ବିଜ୍ଞପ୍ତି ରଦ୍ଦ କରିଦିଆଗଲା ପୁନର୍ବାର ବିଜ୍ଞାପନ ପ୍ରକାଶ କରିବା ପାଇଁ ନିଷ୍ପତ୍ତି ନିଆଗଲା।
And now no fresh advertisement has been issued.
Fresh advertisement.
Take instruction. Counter.
Take instruction only one document. Annexure 5 page number 17. ମନ୍ତବ୍ୟ ଯୋଉଟା ମନ୍ତବ୍ୟରେ ଦ୍ରୌପଦୀ ସୋରେନ ଆଉ ସରସ୍ୱତୀ ହେମ୍ବ୍ରମ ଉପସ୍ଥିତ ରହିଲେ ବାକି ସମସ୍ତ ଅନୁପସ୍ଥିତ ରହିଲେ। ଦେନ୍ ଲର୍ଡସିପ ମେ ପେରୁ ଦ୍ୟାଟ୍ ଆନେକ୍ସଚର 6
ତାଙ୍କ ଲୋକ ନଥିବେ ବୋଲି ଅନୁପସ୍ଥିତ ଥିବେ ବୋଲି କରିଦେଇଛି।
ଏଇ ଦି ଜଣଙ୍କ ଭିତରୁ ଉପସ୍ଥିତ ରହିଲେ ସରସ୍ୱତୀ ହେମ୍ବ୍ରମ ଇଜ ବିଫୋର ଲର୍ଡସିପ। ତ ସେଇ ଯୋଉ ଡକୁମେଣ୍ଟରେ ସେମାନେ ଲେଖିଲେ ଦେयर ଇଜ ଏ ଗ୍ରାଉଣ୍ଡ ମାଇଲଟ ଯାଞ୍ଚ ପ୍ରକ୍ରିୟା ସମୟରେ ଜଣା ପଡିଲା ଯେ ସରସ୍ୱତୀ ହେମ୍ବ୍ରମ the present petition page note 20 I am referring to ସରସ୍ୱତୀ ହେମ୍ବ୍ରମ ବୁଲା ମୁର୍ମୁଙ୍କୁ 19/7/2023 ତାରିଖରେ ବିବାହ କରିଛନ୍ତି ଯାହା ବିଜ୍ଞାପନ ପ୍ରକାଶନର ମାତ୍ର ଗୋଟିଏ ଦିନ ପୂର୍ବରୁ ଥିଲା। ପୁନଶ୍ଚ ଖାଲି ଥିବା ଅଙ୍ଗନବାଡି କର୍ମୀଙ୍କ ପଦବୀ ପୂରଣ ପ୍ରକ୍ରିୟା ସମୟରେ ଅନଲାଇନ ମାଧ୍ୟମରେ ସମ୍ପୃକ୍ତ ଗ୍ରାମର ସର୍ଭେ ଲୋକ ସଂଖ୍ୟା ଅନୁଯାୟୀ ପ୍ରାର୍ଥିନୀ ସରସ୍ୱତୀ ହେମ୍ବ୍ରମଙ୍କର ଉକ୍ତ କେନ୍ଦ୍ରରେ ସର୍ଭେ ରେଜିଷ୍ଟରକୁ ଅନ୍ତର୍ଭୁକ୍ତ ହୋଇନଥିବାର ଜଣାଗଲା। For that reason they sought for a clarification. And since they didn't receive any clarification, my lord, they have decided to cancel it and issue fresh advertisement.
They could have waited. They could have reminded the government for clarification.
This is the ground, my lord. What? I'll take instruction on the bill.
The State Council shall take instructions as to the reasons. No, State Council shall take instructions as to the justification for cancelling the advertisement when admittedly clarification was sought for from the government and the same was not received. Place this matter on on 23rd September. Till such time, I hear it. No advertisement shall be issued, if not already issued in the meantime, till the next date. Shall be published.
As for item 16.
None appears disposed of.
My lord, item 26, my lord.
Item 16, yes. You're on item 16. Disposed of. Item 17.
Same.
Disposed of.
Item 18.
Disposed of.
Item 19.
Disposed of.
Item 20.
In 2011, I have challenged the selection of Anganwadi worker.
How Thibasi?
How called he want to be instructions.
No instructions कर दूँ तो dispose of no instructions disposed of.
Liberty.
He say liberty to that liberty I am giving in every case.
Item 21.
And out of my experience in the High Court, these kind of matters, and mainly when we were taking up those tribunal matters, 99% of the matters nobody comes. In 1%, the restoration is filed, and which we liberally allow.
Okay.
Item 21.
21 year old I'm for the opposite part number 4.
None appears disposed of.
Obliged.
With that liberty.
Item 22.
22. None appears disposed of.
So item 26.
My lord, item 26.
Yes.
I am for the petitioner here, my lord. Your lordship, I prayed for, my lord, 2 weeks time may be given for filing a rejoinder in this case, my lord. The earlier.
Well, counsel for the petitioner seeks time to file rejoinder. Lays this matter. On 30th September, rejoinder will be filed in the meantime.
My lord, interim order to continue, my lord.
Interim order to continue.
Appellate.
So item 27.
None appears. List this matter next week.
So item 31.
None appears disposed of.
In item number 27, none appears next week, the lordship posted.
Yes.
But here in this case, we have already received a para-wise comment.
Next week था उसे देखिए ऐसे petitioner तो ना थे अपन क्या उसको. Item 31 disposed of.
Item 35.
Yes, 35. None appears next week. चला. Oh, weekly रखी थी. Yes.
Weekly list item number 1.
That's all.
Item number 2.
The matter was substantially hard, and if you remember, my lord, it's a suit for declaration of right title interest and confirmation of possession. The defendant is the appellant.
Cool.
The defendant is the appellant, and the
Against a confirming judgment.
against a reversing judgment.
Reversing judgment.
Reversing judgment. But the plaintiff suit was for declaration of right title interest and confirmation of possession. In the defendant entered appearance and filed its written statement along with counterclaim. In the counterclaim, there was a prayer for declaration of right title interest and confirmation of possession and recovery of possession. And the suit was dismissed and the counterclaim was allowed. The plaintiff preferred appeal against the dismissal order, appeal before the ADJ both, and the Law and ADJ on erroneous application of fact and law has dismissed the has set aside the order of the trial court and allowed the appeal, against which the second appeal was preferred. Over the questions of law in the second appeal is concerned, my lord.
I had heard it completely.
Yes,
I had just said I had kept it only.
Yes,
Just I will not be able to pass judgment. That is why I had kept it. I have heard it. How can I close it? Close it.
खाली just reply रे दिगा जिनसे खाली point out.
Reply टे जाकर. I think I have noted whatever you have said and whatever Mr. Khuntia has said. I have noted.
But hard extensively. Extensively it was hard.
How come?
The judgment was. I have also prepared a written note of argument also.
Now both of you can file a note of argument.
Yes, my lord. I have also prepared.
कौन कहाँ है यार वो करे?
खाली दीटा तीनटा जिनसे your lordship remembers. My last occasion, my lord and senior emphasized upon the fact that Exhibit A, which is a registered will executed by the lawful owner in favor of the defendant, was disputed on the ground that the signature of the attesting witness was not on each page of the will, though he had signed in the first page and the last page. But on his page of the will, it was not there. But that was beyond the pleading. That was never argued by. That was never nowhere. It was argued, and it was not there. Also part of the pleading in the written statement to the counterclaim. Therefore, it would be appropriate if I take your lordship's attention to the evidence, both the attesting witness as well as the.
That I've seen on the last occasion. We have gone through the evidence, and again while preparing judgment, I will go through these judgments.
Yes.
You can raise your points. That's all.
That is very clear. From the evidence, it appears that the will was duly proved.
I had also gone through the written statement filed to the counterclaim.
Yes, madam.
That also I have seen.
Yes, you are not shared. I wanted to point out the evidence. Not necessary if your lordship can go through it.
No,
Again.
Hearing concluded, judgment reserved. Parties may file their note of submissions and memo of citations, if any, within a week. Within a week.
reopening
within a week though. Within a week. Yes.
ना सोमवार छुट्टी हो रहा है
No, hell, I see that will not be an issue. Yes.
Only one second. About the illiterate lady, there is an admission by him in WS para 10 वो मो नोट रे लिखि देबी से लिखिछि
Yes, item 3. Chalo, pass on.
Item 4.
Item 4, yes, your matter.
Item 4, that matter where state without being implemented as a party, there has been a decree against it.
Yes.
So he has sought for permission, state has sought for permission, but there has been a delay. For those 3 decisions, I have made a note. I will be submitting your lordship by tomorrow. And the limitation part, I have referred to para 8 of that last judgment, as your lordship might be knowing, that from Manipur, the Supreme Court judgment. There have been other judgments while where it has been discussed about in case of delay on the part of the state, the considerations to be made. All those decisions I will be given by.
With great respect to all the decisions, I still hold the view, maybe a little bit traditional. If there is a substantive point involved,
yes,
then delay will never stand in the way. Normally.
Sufficient
But
cause is the language.
but this cannot be the order in every case.
No, cannot.
No, there are balance has to be struck. Isn't it? Anyway,
By tomorrow, day after tomorrow, I will be submitting.
And Mr. Mishra is not there.
Yes.
You also inform him.
Yes.
Yes.
Day
All right,
after
pass over.
Item number 5.
Vote is there. Pass over.
Item number 6.
Item number 6. Yes, this has come on mentioned.
Respondent 1A to 1B.
Appeal abated against appellant numbers 1 and 2.
Yes.
Yes.
Transfer bit se miscase copy ta mo pare nahi. So 1 week time.
All right. List this matter next week, as requested by counsel appearing for the respondent. Yes.
Respondent.
In the week commencing 9th September.
9?
September.
9.
Item number 7.
Pass over.
Item number 8.
May I please, your lordship, I am appearing on behalf of the respondent, on behalf of the appellants.
Sir, second appeal, virtual mode, it will be very difficult for me to hear second appeals on virtual mode.
My lordship, this is
my incapability, but I cannot, virtual mode or second appeals, and these are all difficult matters. Please appear physically.
my lordship, with leave of the court, these are the substitution petitions. So
what? So what if they are substitution petitions? Please appear physically. List this matter next week. Substitution petition, are they easy matters or what? You have to go through several persons have died, several petitions are there. It's not that easy. You have to appear physically, place each and every single petition. Yes.
No, 9.
Ma'am, please, your lordship. Lordship, I am appearing on the behalf of the respondent, your lordship, and IN number 834 has been filed in terms of
compromise.
Yes, lordship. Lordship, may kindly fix a date for appearance of the.
Appearance of what is used for the other side? Mr. Gopal Mahathi.
I am appearing on the behalf of Gopal.
Who the petitioner? B. Sahu?
B. Sahu.
B. Sahu K.
Bomke Sahu.
Bomke Sahu. You ask him. He must be there somewhere. All right.
I have got instruction from him. His.
All right. IA 1834 of 2024. This is an application for recording the compromise between the parties on the terms mentioned in the petition itself. Let both parties appear personally before this court on Kebe next week.
Yes, Lord.
In the week commencing 9th September. Jodhana padibo?
Yes, Lord.
9th is? No, supplementary kar diyo. Supplementary. Place this matter on Kebe date kar diyo. 9th ko jabi kuch on 9th September in the supplementary list.
Lord.
But ask Mr. Sahu to also appear.
Yes, Lord.
Ask them to come with their identity proof and all that.
Lord.
Yes.
Item number 10.
Pass over.
Item number 11.
My lord, item 11, I am for the respondent number 3, my lord, on behalf of Mr. R.K. Raut, lordship.
Respondent 1, 2, 3. All 3 have deceased.
Respondent number 1, 2, and 3.
My lord.
So you are appearing from whom?
My lord, on
Respondent,
behalf-
sir, they were-
respondent number 3, my lord.
Yes, yes.
Respondent number 3, your lordship.
3, not for 1 and 2.
No, my lord, 1 and
1 and 2,
only-
somebody else was appearing.
Yes, your lordship.
1 and 2, somebody else was appearing.
Yes, your lordship.
Now, respondent number 3, will you appear for the LRs?
My lord,
Do you have instructions? We will issue notice. Is there any delay?
Yes, your lordship.
ତିନିଟାଙ୍କର delay ଅଛି ମୁଁ delay ମୁଁ ତାଙ୍କୁ ଆଜି ତିନିଟା କିନ୍ତୁ କପି ଦେଇ ଦେଇଛି ମ୍ୟାଡାମ।
IE କେତେ କହିଲେ?
274/2024.
ନାଇଁ ସେଇଟା ନୁହେଁ ରେସ୍ପଣ୍ଡେଣ୍ଟ ନମ୍ବର 1 your lordship IA number 274/2024 is regarding abatement setting aside abatement.
You will have to take up the delay 2 years and 1 so notice has to go. All the 3 petitions will send notice. But he has no instructions to appear for respondent 1 and 2. Let notice go. Why are you taking the risk? Let notice go. Notice go. तापरे बाकी कौन को बाकी उड़ा? One gala 274, 5 and 6.
274, 5 and 6.
This relates to respondent number 1. 2 by
2.277 ହେଲା ଆମର
yeah 277, 278 and 279 is for
ଆଜ୍ଞା ସେ abatement ଆଉ delay conversion and substitution.
तापरे 280, 281 280 for 3. है तो ये तीनटा को group of petitions को रेडी करी issue notice to the proposed LRs of respondent number so and so जहार जोटा को as per the schedule, the details of whom is mentioned in the schedule. Stop. Notice be issued by registered post with a registered post, fixing a short returnable date. Requisites be filed within 3 working days. Less this matter in the week commencing 21st October.
Maybe excused. Prayer, my lord.
Yes.
Since respondent number 3 he was appearing, only 1 2 I may take.
No, he is ambivalent. You take notice. It is better. For your own benefit, I am saying. Notice नहीं किसी appear करेगा मना आज.
Maybe excuse item 10.
Item 10. Yes.
There is also IA for substitution and IA for delay in filing of substitution.
कितने दिन delay?
Delay मरी जाइथिले तेनु तार इंटिमेशन नथिला.
ये delay कितने दिन को होती?
अब वर्षे कोठे 13 वर्ष
नहीं there has to be 3 applications. One is for delay, one is for acetic acid abatement, and one is for substitution. You have provided only 2 applications. There is an application for acetic acid abatement.
Setting aside of the
file करिए पूरे वो civil matter ये statutory appeal
सेटा अच्छी सेटा भूले फाइल ने मैं देखो सेटा अच्छी
फाइल कर दूँ
आगे नेक्स्ट वीक था
फाइल कर दूँ ना ठीक है ना
नहीं सेटा ये है
नहीं affidavit भी करना और leave this matter next week as paid for.
Hello.
We commencing 9th September. The report was
There are 2 tickets.
4B and 4A.
Sir, authentication fees could be only the total chapter. I will pay them. So in the meantime,
Defects be removed in the course of the day.
respondent has died.
All right.
And to substitute the LRs, I filed a petition.
What is the delay?
Delay is there.
कितने दिन?
100 days for which I filed 100.
Sir, take notice
I will take notice.
on the proposed LRs. All right. Issue notice to the proposed LRs of the sole respondent. The details of whom are mentioned in the schedule. In the body of the petition itself. Schedule be in the schedule. Requisite notice be issued by registered post fixing short returnable date. Requisites be filed within 3 working days. List this matter in the week commencing 21st October.
My anxiety is, in the meantime, LRs have been substituted in the execution case. LRs have filed the execution case, they are proceeding, there is a direction that immediately.
You file an IA?
I filed a petition for stay of the operation of the impugned order.
In
the meantime, before the appeal could be admitted, they have filed the execution case, they are proceeding, and the court says, unless you approve the stay order, commission will be issued, we will vacate you and take position. That is my anxiety.
Appeal की stay मैंने ये नहीं.
Appeal admit है नहीं अपन तो.
अच्छा हो.
But in the appeal, I filed a petition for stay saying that operation of the order is stayed. That if that is done, it will be sufficient.
How can that order be passed now when the sole respondent has died? Notice on appeal.
Kindly say it because that is my.
See, miss case number 611 of 2013 जो
There is a call from.
till the next date. The operation of the judgment and decree passed by the courts below shall remain stayed. Yes,
Urgent circuit.
urgent copy.
13.
Pay for a password.
Password.
Item 14.
Please, Your Lordship. Item 14, I am for the appellant, Your Lordship. Where I have filed one memo for deletion of name of respondent number 1 as her only legal heir.
Respondent 4 लिखा है जी.
That has already been deleted, Your Lordship, by the order dated 26/10/2017. That was earlier, Your Lordship.
Already deleted, yes. Now you have filed another memo.
Another memo, Your Lordship.
Where is that memo? It's not there.
As per noting, memo is at flag 50, Your Lordship.
But then there are some petitions for substitution, setting aside and all that.
That has been filed by the respondent number 5. He has filed one cross objection. I have not been given the copy of the cross objection nor the substitution application.
So where is your memo?
Memo is at flag 50, Your Lordship.
Flag 50, okay, all right, all right. The name of respondent number 1 be deleted at the risk of the appellant as per memo filed by him. Copies of the cross objection be served upon learned counsel for the appellant. Is this matter?
8th October.
In the week commencing 20, I have to short date karo, right? Substitution that's
7th October.
all right, on 7th October.
There was interim order, Your Lordship.
Interim order to continue. Okay.
Your Lordship. Oblige.
Item 15.
15. This is a transfer brief that I am filing the consolidated cost title.
No. Consolidated cost title of the appeal memo is filed in
So
court.
far as the requisite
Same be kept on
filing
record.
of the requisite, that because at that time, Satyanarayan Mahapatra was appearing for the sole respondent.
You have filed or
Respondent number
you have filed or you want to file?
I will file.
All right. Requisites for issue of notice on the LRs of respondent number 1 be filed within 3 working days. Notice be issued as directed earlier. Yes.
From 8th October.
List this matter on 28th October. In the week commencing, huh?
Item 16.
Item 16, Your Lordship, on behalf of Advocate Mr. Devendra Kumar Sahu, I pray for after lunch.
There are two IAs, that is at flag C and D. In the first, at flag C, the IA we have filed to pursue the second appeal through the legal heir of appellant number 3 because appellant number 3 had passed away at the time of passing of the first appellate order. And then because of that defect for not impleading appellant number 3 as a party, Lordship, this order dated 31/10/2019 was passed, which is a peremptory order to remove that particular defect, which was passed without taking into consideration this leave application. So that may be recalled and this IA may be allowed to pursue the second appeal through the legal heir of appellant number 3. Then
Okay, just a moment. Yes.
order number order dated 31st October 2019 was passed without taking into consideration our IA which was pending. Then after that, these two IAs, Lordship, I'm also pressing the IAs at flag E and F, where appellant number 1 has passed away, and the legal heirs we have instructions to appear on behalf of the their appellant number 1's legal heirs, and there's a delay of 59 days. And the respondents have already made an appearance by filing caveat, and we have served a copy on them.
Where is that IA which you said was pending and was not taken note of?
It is at flag C. IA number 645 of 2019.
It is submitted that the order dated 31/10/2019 was passed without noticing IA number 645 of 2019, which was on record. As per the said IA, in the said IA, leave was sought for to implead the LRs of deceased Pandav Behra, appellant number 3 in the lower appellate court. Stop. It is submitted that the LRs of the deceased appellant have an important stake in the matter, and therefore the other appellants may be permitted, and that they may be permitted to join the other appellants in this appeal. Considering the submissions, the IA is allowed. The appellants are permitted to pursue the appeal. The LRs of LR to join us.
Already Nirman Charan Jana, appellant number 6 dear.
He has already been impleted.
We have impleted by taking this.
Nirmal Chandra Jana.
Niman Chandra Jana.
Nimai Charan Jana. Nimai Charan Jana, son of deceased Pandav Jana, be impleted as appellant number 6. Consolidated cost title be filed within 3 working days. Yes. Then we go to the other 3. 645 of to the light. 890, 898, 440.
Recall that peremptory order.
898 है कल से इतना कर दूँ 898 और 8 को मिस ही कर दो इधर मिस पे नहीं हो order dated is hereby recalled off. Then
Flag EOF ref substitution for appellant number 1.
there is an application for setting aside abatement.
There is no abatement is 60 days. So
there's no delay. But why have you filed a?
There is a delay of 59 days. Abatement application.
File
Abatement haba kathos. Only IA limitation to file kuchu. I'll file abatement application. 59 days delay.
There no abatement file मुझे जाने नहीं पचास चपनों
60 days
अरे we learn from each other every day मुझे जाने पचास चपनों कीमत अब तो abate ही ना automatically. So first you have to file a petition to set aside that abatement so that the appeal is restored subject to delay, condonation of delay. Right? You file an application. Let this come next week. Whatever you want to file.
So another IA, that is IA number 729 of 2024, which was filed on 1st of July, which has not come on record.
It is there. It is on record.
Lordship, that is the urgency actually why we mentioned.
It is there on record. Tell me what is the urgency.
Then, Lordship, actually the suit land is a Noyanjuri land. And because it is monsoon season and the appellants are all villagers.
What is non-jodi?
Non-jodi is a water channel.
Where is it located?
This land is at
non-jodi ta koi jagah tha hai?
Agricultural land Majhe.
Majhe nahi. Rasta kodar jo rasta ru jami bhitere jo jagah ta seta kondi non-jodi. You are right when you say that it's a passage of water. So you'll see when you go to on a national highway, you'll see the road is at a raised level. Then there's a dhalu. Good land aramo. Say jaga to non-jodi. Yes.
So because it is monsoon season, there is no other outlet of runoff water. So the appellants are cultivators. So if the water is collected and what is happening is at annexure 1.
Let it come next week. You first regularize the matter by filing that petition for setting aside abatement. I will hear on merits because this requires a little bit of hearing. What is your right over the non-judi? Non-judi is public land. So you are seeking an injunction against the defendants over that non-judi. Unless you.
The nature and character of that.
All right. But since that land doesn't belong to you, it belongs to the state. How you have said that the respondents may be restrained from digging earth and changing the nature and character of the scheduled property. Now, you scheduled property and non-judi. What exactly do you want? That you have to clarify. Let this matter next week. If necessary, prepare a map. Yes.
Next Monday. In that.
Next week, weekly list. The weekly list of Tasio, Monday. Yes.
Item 17.
Respondent's application for early hearing of the appeal.
I am also ready, your
I know
lordship,
it was
for hearing.
It was the IA was heard by your lordships. On your lordship to find that it must be taken up under the heading of orders and it will be heard. But that impression it has come.
We can take it up today and we'll keep it a part heard on the next week. As you part heard केतरा আছে আর week रे देखलो किसी न थियो part heard केतरा আছে किसी नहीं we'll keep it as part.
Lordship may keep it for hearing.
The LCR is there.
LCR as it.
Admission ही है
Again.
substantial question of law frame is answer. We'll hear it.
Monday.
कहीं आज आराम करो ना थी आज आराम करो
Orders रे आस्तिला.
orders से कौन है सब orders कौन admission कौन matter तो आसी सुनिबा कौन orders कौन is technical मत कौन daily extend बोले भाबुचंदी orders पर सेगुडा कौन देखि matter टा म सामने चाहिए म सुनिबी if it is ready.
And since I am for the appellant, I prefer.
आपण ऑइल दे मु से OJC section रो लोक होले
Lordship may keep it part heard and your lordship may place.
all right heard in part let's just matter next week.
Right.
So it will come at the top of the list
Yes, yes.
along with the other part heard matters that may happen during this week.
Yes.
Yes.
Item number 18.
कितना छे कोडी ना
Item 18,
Note of the
lordship, ADs of appeal notice issued on respondent 1 to 5 has not yet been received. Your lordship will take fresh steps in that.
No, address left without instruction from respondent number 4 with the report unknown. AD not back from respondent number 2. When was notice issued?
2021.
ताले postal tracking report होबने.
Respondent number 1 died in the meantime.
Okay, so you have to take steps for substitution. It is stated at the bar that respondent number 1 has died in the meantime. 2 weeks time is allowed to the appellants to take steps for substitution. Issue notice on respondent number 2 and 3 with by registered post with AD returnable within 4 weeks. ना 2 to 4 भी होगा ना 2, 3 and 4 कर दियो 2, 3 and 4 है ना fixing कौन short returnable days list this matter 11th November.
Lordship, noting the respondent 1 to 5 be not received.
5 को था किसी लिखा है नहीं नहीं let us see the office note 5 को था किसी लिख लेने कौन कुछ चलो 5 भी कर दियो 2, 3, 4 and 5
Substitution petition if served and I have instruction to appear for the purpose legal heir. I have filed the memo.
See the substitution petition करना थे हमें किंतु करिए petition टा करो
Not 17, 18 order to continue.
item 17 18 order to continue.
No, 19.
19 अच्छा कौन होगा 21 पर चलता है 18 डे
11th November.
अच्छा हाँ 19 yes
The fresh notice by R3 against.
no postal tracking report is there let us see item delivered postal tracking report shows that notice on opposite party number 3 respondent number 3 was delivered there is however no appearance then what else is there
Section 5 limitation act.
Limitation. Sorry,
weekly list ଅଛି ତ we'll pass it over କାଳେ appear କରି ପାରନ୍ତି week ଭିତରେ ଯଦି appear କରିବେ limitation ରେ notice ଯାଇଥିଲା ତ
ଆଜ୍ଞା
control it but let them appear pass over କରି ରଖନ୍ତୁ
item 9 ଟା non appeal से जाई तो compromise हे जाई
non appears तो ही non appears ही both parties have been directed to personally appear
मतलब
yes
Item number 20.
ସେତିକି ଥାଉ 20 ରେ work କର କରିବି ଦୋହରା ଦେଲା 50 ପୁଣି 70 ଟା ମ୍ୟାଟର ନେଇ ସାଳ yes
May I please, Lord. I am appearing on behalf of respondent, Lord.
pass over for the week day ଆଜି ଯାହା ହବ
Pass over.
ପାସ୍ କଣ ହେଇଛି?
Short date କଲେ ମୁଁ interview ପଇସା allow ହେଇନି. Short date stage continuing.
All right, next week.
Item 1.
Item 1.
Part matter item 1.
Weekly list.
Week.
Yes, I'll take up. I'll take up after this admission matter. If orders matters are over, I think I will take up that matter. Yes.
Item 21.
20.
Wait, please, your lordship.
Item 20 was there.
21. Take fresh notice.
Your lordship, my humble submission is that, your lordship, they have filed one final decree proceeding, your lordship. And in that final decree proceeding, they have given the same address that I have given in the appeal memo, your lordship. So my humble submission is that they are deliberately avoiding the notice, your lordship.
We will issue notice by both ways through court process as well.
Your lordship. And one more request, your lordship, I have
Issue fresh notice on respondent numbers 1 to 4 by both ways. That is by registered post with AD as well as by court. As well as through court, fixing a short returnable date. Requisites be filed within 3 working days. Place this matter on. No, short date. 21st October.
One more request, your lordship, I have filed one IA 572 of 2024.
Yes.
Your lordship, for stay of final decree proceeding, your lordship, because at the time of admission of this appeal, there was no final decree proceeding.
Yes.
Now they have filed an application for final decree proceeding. So, your lordship, may kindly stay that final proceeding decree till disposal of the second appeal, your lordship.
IA 572 of 2024. The final decree proceedings shall continue, but the decree shall not be sealed or signed without leave of this court. Let's take the next one.
I'm okay.
20 पर pass over है ना? Item 20.
Item number 20.
The state's appeal against conforming judgment. In the appeal, though it was varied to a small extent, but the substantial questions of law, of course, that your lordship will be considering after delay is condoned.
Yes.
500 days delay.
Yes. Is what you say?
Lordship.
You have any objection?
Lordship 500 days delay, Lordship. Delay may be condoned, Lordship, for on merit, Lordship.
Office has pointed out delay of 469 days. Stop. It is stated that the fact of passing of the judgment by the learned district judge was not within the knowledge of the state petitioners, and the same came to their knowledge only when they received notice of the execution case. In the process, there has been delay. Learned counsel appearing for the respondents has no serious objection to the petition for condonation of delay. Has no serious objection to the delay being condoned. Considering the submissions, the delay in filing of the appeal is condoned, subject to payment of cost of rupees 1,000 to be paid to the counsel for the respondent, and receipt be filed before this court. List this matter next week, or yeah? List this matter next week for admission. In the week commencing 17th September.
There is another office note about the appearance of the respondent number 1.
You remove the discrepancy.
Lordship.
Learned counsel for the respondent is directed to remove the discrepancy in the Wakalathrama
Lordship.
and the appeal memo.
Lordship.
Item number 22.
Pass over.
Item number 23.
My lord, noting is the return answer from the sole respondent, the report is on insufficient address, but we have filed the address which is filed in the court below.
All right. issue fresh notice on the respondent by both ways, that is by registered post as well as through the court process. The requisites be filed within 3 working days. A short returnable date be fixed. List this matter on in the week commencing 21st October.
Item number 24, my lord. IA number 8041 of 24, my lord.
Yes.
IA number 8041.
Yes.
An application for dispensing with the service notice against respondent 3 to 23.
It was dispensed with.
Yes, ma'am.
Then we'll ignore the office note.
They were
Dekhe.
defendant number
Dekhe.
1.
No, it was said that you notice to all respondents.
I have filed this application for dispensing.
IA number?
IA number 841 of 24.
IA 841 of 2024. Considering the submissions, the petition is allowed. The notice on respondent numbers 3 to 23 is dispensed with for the time being.
Yes, ma'am.
At the risk of the appellate. Issue note. List this matter in the week commencing 18th November.
Another application is there, my lord.
Yes.
For subsumption of the sole appellant, my lord.
Sole appellant has died.
Yes, my lord. The application is within time. We have appeared. The legal heirs have already appeared.
IA 840 of 2024 is an application for a substitution of the sole appellant Mir Masood Ali, who is said to have died on 15/7/2024. The present application is in time. It is submitted that his legal heirs, that the right to sue survives in favor of the legal heirs. Correct. The prayer for substitution is allowed. The alerts of Mir Masood Ali be impleted as respondent numbers 1A to 1D.
Appellant number 1.
Appellant number 1A to appellant number 1D. Hello. Consolidated cost title be filed.
Yes, ma'am. Within a week.
Within a week. The substituted appellants are represented by Sri D.P. Mati,
Yes, ma'am.
Advocate and Associates. Yes.
Interim to continue.
Interim to continue. Is this matter? 18th November. Yes.
Item 45. Already filed.
Certified copy.
Yes.
So IA is dismissed as infructuous.
Second. 25 रे 26 रे मध्ये फाइल करछन
26 November same.
26 टा किंतु अर्जेंट अछि आगा आर सप्ताह रे
Oh, list this matter next week for admission. 25 टा भी से कर दे 17 कर दे 25 टा 17 एटा को नेक्स्ट वीक कर दे. Yes.
Item 27.
Password for the day.
All right, pass over. Please, pass over. I'll take up pass over matters now. Pass over hearing matters. Orders are complete, so.
So item number 1.
If directed to take instruction, not have communicated the party my lord.
What instruction?
Whether the agreement it is for the valid agreement, I will have to take steps to contact.
No, I think there is something else.
That is an agreement to sell, my lord. And their prayer is that to execute the sale deed, direct the defendant number 1, 2, 3 to execute the sale deed in their favor in respect of the disputed land, and to cancel the sale deed executed by defendant 1 and 3 in favor of the defendant number 4 and defendant number 4 to 5. Now the appeal has been dismissed against defendant number 4 with the respondent number 4. When the appeal has been dismissed as against respondent number 4, then the decree is not executable as against the 4 and 5. So entire appeal should go. That was the argument.
In this suit, my agreement is valid. My lord, this is a registered agreement. My lord. Suit is allowed. My lord. London Court directed to execute the sale deed in favor of me. Thereafter, they are suppressing the material fact and without intimating the earlier agreement, they have sold the purchaser. They sold the land without the intimation to me. Thereafter, London the Appellate Court allowed the appeal on the ground that there is a mere discrepancy in the suit land. My lord.
So you wanted to take instructions from your client?
My lord.
What are your instructions?
नहीं contact है ही नहीं था सर 1 week रही आर दिस्पोज कर One week better oil se Bhubaneswar registered post ki jawab na janai dwa diya.
As requested by counsel for the appellant, is this matter? 17th September.
17.
So item number 3.
Item 3.
Your Lordship. Last time that is only.
I think I'll just close it. Mr. Rathore wanted to argue something, but he's not there today. What can be done?
It is covered by your Lordship decision. That Bombay decision, Ramanand Patil. Your Lordship has taken a decision, paragraph 70.
No, I've seen, but he was referring to section 15. He said that the provision of section 15 has not been taken note of.
Kerala decision, this partner decision 83, which was relied by the trial court.
All right, we'll do one thing.
That was approved by the Supreme Court in 2008.
No, Mr. Rao, Mr. Rathore is not there. He is probably out of station. Somebody was making a mention in the first half. So I will keep it to tomorrow. It is already in the list. Tomorrow I will call out. You please inform his associate that tomorrow it will be taken up. If it doesn't appear, end of the matter, I will close it. I've heard it many times. I don't want to hear it again.
Written submission.
Yes. The written submission, though, obviously, but I don't want to.
Already given my.
All right. Yes.
One more, Miller, I have to add that 83 partner, exactly similar to your Lordship's decision, that was approved by 2008 Supreme Court and say the matter is no more recent. All the things that is section 14, they have dealt with and passing the order.
Yes.
So item number 5.
You were to begin today?
My lord.
Thank you.
May I please, Your Lordship? Your Lordship, by order dated 5/8/2024.
Yes.
Has framed as many as 5 substantial questions of law.
Yes.
First of all, I will argue the first substantial question of law with regard to authority of the person who has signed the plan.
Yes.
Their case is the person who has signed the plan and verified it, that
Yes.
is not as per the law. And for that, this substantial question of law is framed.
Yes.
Now, on this point, I will take your Lordship, first of all, to order 6, rule 14.
Yes.
Order 6, rule 14.
Yes.
Every pleading shall be signed by the party and his pleader, if any, provided that where party pleading is by reason of absence or for other good cause unable to sign the pleading, it may be signed by any person duly authorized by him to sign the same or to sue or defend on his behalf. It is duly authorized. I am placing it on duly authorized.
Yes.
It does not say he must be acquainted with the facts of the case and other things. Then I will take your Lordship to order 16, rule 15 regarding verification part. Save as otherwise provided.
Order
15, rule 15. Order 6, rule 15.
Order 6, rule 15.
My lord.
Yes.
Save as otherwise provided by any law for the time being in force. Every pleading shall be verified at the fort by the party or by one of the parties pleading or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case. They are acquainted with the facts of the case. It does not say like 14, rule 14, duly authorized. It does not say so. Then I will take your lordship to order 41 rule 1. Same parameter provision there, order 41 rule 1. Order 41 rule 1. Every appeal shall be prepared in the form of a memorandum signed by the appellant or his pleader and presented to the court or to such officer as appoints in this behalf. Other things, I am on that, my lord. Either by the party or by the appellant. Sorry, either by the appellant or by the pleader. Here. Then your lordship may kindly turn to order 3 rule 2. Order 3 rule 2. My lord, order 3 rule 2.
Order 3.
Recognize agent. The recognized agents of parties by whom such appearance, applications, and acts may be done or done are made or done are a person holding power of attorney, authorizing them to make and to do such appearance, application, and acts on behalf of such parties. It does not, to my submission, does not say about plaintiff. Then B, person carrying on trade or business for and in names of parties not resident within local limits of the jurisdiction of the court, within which limits the appearance, application, or act is made or done in matters connected with such trade or business only, where no other agent is expressly authorized to make and do such appearance, application, and act. It is not applicable to me at all. Only rule A, sub rule A. Now, your lordship may kindly, since my friend has argued, your lordship may kindly turn to order 29 rule 1. This is suit by or against corporations. Lordship got it?
Yes.
So it does not say about individual person. It says about a legal entity. Then in suit by or against a corporation, any pleading may be signed and verified on behalf of the corporation by the secretary or by any director or other principal officer of the corporation who is able to depose to the facts of the case. So it has nothing to do with the signing of the plaint so far individual person is concerned. And specific thing is mentioned in this case. And furthermore, my lord, now Mr. Parija has signed the plaint that is accepted by the plaintiff. He has filed the plaint. Your lordship may kindly see the plaint, my lord. The plaint is by Prabir Kumar Das, represented by authorized representative Akshay Kumar Parija. So the plaintiff has not objected to this, rather accepted this. So assuming my submission is there is no illegality or infirmity in signing the plaint and verifying the same by this Akshay Kumar Parija. Assuming but not admitting that there is a defect or irregularity that is curable. That is not illegal, but that is curable. If a thing is curable,
yes.
If a thing is curable, it cannot be said that it is mandatory. And furthermore,
yes,
for the defect in pleading, signing or verifying, it is not mandatory. There is no consequence that if it is improperly signed or verified, the consequence is there that it will be dismissed. Nothing is there. So it is not mandatory in nature. Now on this point, I will cite certain decisions. First of all, my lord, flag A, your lord's mechanical turn, that is 2006 1 SCC 75. Your lord's may kindly turn to paragraph 13. Is not necessary, but for the purpose, paragraph 13 bottom, my lord. Considering an application that the pleading was not signed properly, my lord, the object of courts is to decide the rights of parties and not to punish them for mistake which they make in the conduct of their cases by deciding otherwise than in accordance with their rights. Courts do not exist for the sake of discipline, but for the sake of deciding matters in controversy. Then, my lord, your lordship may kindly turn to paragraph 15. Paragraph 15, my lord. It is thus now settled that any defect in signing the memorandum of appeal or any defect in the authority of the person signing the memorandum of appeal or omission to file vakalatnama executed by the appellant along with the appeal will not invalidate the memorandum of appeal if such omission or defect is not deliberate and the signing of the memorandum of appeal or the presentation thereof before the appellate court with the knowledge of the authority of the appellant, such omission or defect being one relatable to procedure can subsequently be corrected. It is duty of the officer to verify whether the memorandum of the appeal was signed by the appellant or his authorized agent or pleader holding appropriate vakalatnama. If the office does not point out such defect and the appeal is accepted and proceeded with, it cannot be rejected at the hearing of the appeal merely by reason of such defect without giving an opportunity to the appellant to rectify it. The requirement that then other things are 2 lines thereafter. If and when the defect is noticed or pointed out, the court should either on an application by the appellant or summatory permit the appellant to rectify the defect by either signing the memorandum of appeal or furnishing the vakalatnama. Then paragraph 16 again. Paragraph 16. An analogous provision is to be found in Order 6 Rule 14 CPC, which requires that every pleading shall be signed by the party and its pleader, if any. Hence, here again, it has always been recognized that if a plaint is not signed by the plaintiff or his duly authorized agent due to a bona fide error, the defect can be permitted to be rectified either by the trial court at any time before the judgment or even by the appellate court by permitting appropriate amendments when such defect comes to the notice of during hearing. Then 17. Non-compliance with the procedural requirement relating to a pleading, memorandum of appeal or application or petition for relief should not entail automatic dismissal or rejection unless relevant statute or rule so mandates. Procedural defect and irregularity which are curable should not be allowed to defeat the substantive right or to cause injustice. Procedure and other things. So here then another flag B, my lord. Flag B.
Yes.
2096 volume 6 SCC 660. 1996. Volume 6 SCC 660. Your lordship may kindly turn to paragraph 12 and 13. It relates to a case under Order 29 Rule 1. Okay. The courts below having come to the conclusion that money had been taken by respondent 1 and that respondent number 2 and the husband of the respondent number 3 had stood as guarantors, and the claim of the appellant was yes, my lord. Last sentence. Claim of the appellant was justified. It will be travesty of justice if the applicant is to be non-suited for a technical reason which does not go to the root of the matter. The suit did not suffer from any jurisdictional infirmity, and the only defect which was alleged on behalf of the respondent was one which was curable. Then 17 is also, my lord, paragraph 13 is also same, my lord. It is curable. Then, my lord, flag C. Flag C. It is that is 1999 volume 2 SCC 217. It is an election petition, my lord.
Yes.
My lord, I need not place the entire thing, my lord. Just 2 lines from the bottom, my lord. This court has laid down that non-compliance with section 83 may lead to dismissal of the petition if the matter falls within the scope of Order 6 Rule 7, Order 6 Rule 16 or Order 7 Rule 11 CP. Defect in verification of election petition or affidavit accompanying the election petition has been held to be curable, not fatal. So, my submission, my lord, the office, while the plaint was submitted, when the office note was prepared, this defect was not pointed out. In the written statement only, your lordship may kindly see the written statement, only one sentence. In paragraph 3.
Yes.
Paragraph 3 of the written statement, that the present suit filed by a person having no legal authority to file the same, therefore the suit is liable to dismiss on this score. This was the only averment, my lord.
Yes.
Now, these averments has been taken into consideration after evidence by the trial court. Trial court, relying upon this 2006 volume 1 SCC, has categorically held that it is a curable defect and there is no defect at all. And he has accepted it. The first appellate court has also accepted it. So
yes,
it is not a substantial question of law at all. My lord, all illegalities cannot be said to be a substantial question of law. The court may commit an illegality, but the said illegality, if not substantial in question, that cannot be said to be a substantial question of law. And for this, my lord, I have already submitted before lordship, there is no consequence for non-compliance or defect. There is no consequence. Like your lordship may kindly visualize for a moment, Order 7 Rule 11. If there is some defect, so that the suit is, there is no cause of action, that the suit is barred by law, or the suit is drafted in an insufficient stamp paper, then by virtue of Order 7 Rule 11, plaint can be rejected. But for this, that the plaint is not signed by the authorized person and verification is not proper, plaint cannot be rejected nor dismissed, since it is held to be a curable defect. So my submission is, basing on these 3 decisions and my submission, this being a curable defect, this is not a substantial question of law. And when more particular, both the courts, fact-finding courts, and first appellate court is facts of law, facts and law, my law. So this cannot be entertained in second appeal. This is not a substantial question of law. This is my first point, my law. Then, taking to your lordship, to the next substantial question of law, that is yes, my lord. VI, thought I check. VI. 6th substantial question of law, my lord. Yeah, in the appellate court, an application under Order 41/27 was filed for giving some additional evidence. And those documents which are sought to be laid as additional evidence was not prior to filing of the suit or filing to the written statement. It came during the pendency of the suit, and whether those documents can be accepted as substantial question of law, additional evidence by virtue of order 41 rule 27 of CPC, that is to be considered by your lordship, and whether, and that has been rightly rejected by the lower appellate court, which is placed by my learned friend before your lordship earlier. So I need not place that. But my submission is here. Your lordship may kindly see for a moment order 41 rule 27.
Yes.
Procedure of additional evidence in appellate court. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. But if the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted, it is not applicable, my lord. It was not so. Then A. The party seeking to produce additional evidence establishes that notwithstanding the existence of due diligence, exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appeal against was passed, or D. The appellate court requires any document to be produced or any witness to be examined to enable it to pronounce the judgment or any other substantial cause. Now here, his case may come in double A, my lord. But my submission is, these documents were not when the suit was filed, when the written statement was filed. These documents have been kept in during pendency of the suit, and it was not tendered during trial. So at this appellate stage, they cannot brought these documents on record to fill up their lacuna. And furthermore, rejection and suppose, my lord, this application would have been accepted. Then on that basis, the suit cannot be dismissed, or the judgment would have not been otherwise, my lord. It is not their case. Only, and the purpose of why the documents were not, it is not there. And furthermore, my submission is, the first appellate court rightly rejected the application, and the application filed them comes under sub rule 1 AA, and it does not satisfy, the application does not satisfy the requirement of this section, this rule, my lord. And furthermore, this is not a substantial question of law at all. It is not a substantial question of law at all.
Yes.
Now, my lord, on the last occasion, my learned friend argued about the valuation of this suit, but no substantial question of law is framed. If your lordship will frame, permit me, I can argue on that.
I can frame it, but you can make your argument. I can frame it formally.
No, my lord, my submission is, payment of court fee or non-payment of court fee is a matter within the state and the plaintiff. Defendant has nothing to say, and my lord, trial court has rightly held that suit is not under valid, proper court fee has been paid. Appellate court has confirmed that.
Yes.
And even if, my lord, your lordship will find that the suit is under valid, then an application under order 711 would have been filed. My learned friend has cited a decision, Maitri Mahanti and another, Samotra and another. There, the application was filed under order 7 rule 11 of CPC, that was rejected. And this honorable court remanded it, directing the trial court to hear the same afresh, not that it is adjudicated or plaint is rejected. Furthermore, my lord, if your lordship will find in the second appeal that no, court fee has not been paid, it is under valid, then what to, on that basis my suit cannot be dismissed. But at best, this honorable court may direct to recover that amount. If I do not pay, then decree will not be effective. That may be the order. But suppose, my lord, your lordship comes to a categorical finding that court fees are payable, And according to my land engineer's submission, it is 15 crores. If 15 crores is court fee is payable according to him, 45 lakhs some odd. Assuming my lord. But if that is so, in appeal, as well before this honorable court, my land friend will first pay 90 lakhs court fee. Not I. So unless he pays the court fees, here at least 45 lakhs some odd in the second appeal. If your lordship find that is undervalued, court fee is to payable. He has to pay the court fee before this honorable court first.
Yes.
So my submission is that it being a matter within the state and the plaintiff, it under no circumstances, it can be a substantial question of law, since defendant has nothing to say on this. 7 except filing an application or also will do 11. So this is not a substantial question of law to be argued in a second appeal. Then I will take your lordship to the other points, but before that, why I have filed this suit?
Then this, if I understand it, the suit is premature.
No, my lord.
That is what one of the grounds.
We'll come to that.
One of the major grounds is that
That is premature.
that was during pendency of the agreement when the stipulated date had not come, if I remember correctly, whatever that date was, and they received that approval of the BDA and all those things. So there some time was spent there. But in any case, before termination of the agreement, let me just rephrase the question so that it will be easier for you to. But I mean, when the agreement itself was in subsistence, what was the cause of action to file the suit? And it was according to them, it was premature.
Submission, I disagree with that. Neither the agreement nor the power of attorney was
No,
successful.
this is not my view. I am just.
I understand, my lord. Now I will take on that point. First, I will take your lordship
whatever
to the relevant law. Now, your lordship may kindly see when the agreement, development agreement 7/8/2020,
Yes.
and the other was.
So you are arguing on this premature aspect.
No, my lord. On points of law, why I filed this suit. Then
That relates to which substantial question of law?
my lord, it will cover all.
Okay, all right.
But thereafter, I will premature, I will argue specifically.
All right.
First of all, your lordship may kindly see the first development agreement is dated 7/7/2020. And
7/7?
2020, sorry.
Yes.
And the next one is supplementary agreement on the next day, 8/8/2020.
8/7.
8/8.
তাহলে প্রথমটা 7/8 রইতলা
7/8.
আচ্ছা 8/8
এটা 8/8 next day.
Supplementary
agreement. And then power of attorney was executed. Power of attorney was executed and registered on dated 3/9/2020. That is exhibit 2, my lord.
Exhibit 2. Yes.
Now, your lordship kindly for a moment see that general power of attorney. Second page, my lord.
ঠিক আছে পাইবা কষ্ট হবে ঠিক মতো
There is no dispute that the plaintiff has executed the power of attorney.
anyway আপনি কই দিও তো কারণ পাইবা it will be very
Again.
difficult for me to
Page 2 of the power of attorney say, and where I, the above named executant principal, have entered in a development agreement with creative consultant, a registered partnership firm, being PAN number such and such,
yes
other things. So here, the general power of attorney was executed in favor of the so-called partnership firm, represented by the deceased Vibhuti Bhushan Patra, and so also the agreements. Now, my lord, I have filed in the suit. Neither I have disclosed, nor they have disclosed, but they ought to have disclosed. Who are the partners in that partnership? What are the numbers? But from the pleading itself, it is a partnership within 2 persons, husband and wife. And fact remains, and if on 14/12/2020, Vibhuti Bhushan Patra, the managing partner, has expired. There is no dispute. They have exhibited death certificate, and it is their written statement. It is also my pleading. Now, your lordship, at this moment, kindly come to the Partnership Act, my lord. Yes.
back करो अरे back करो partnership
Partnership Act again.
back करो section
First of all, I will take your lordship to section 42. Thereafter to other provisions, madam.
please place it
Again. 42. Dissolution of happening certain contingency subject to contract between the parties.
yes
Subject to the contract between the parties, between the partners, a firm is dissolved. I am on C, my lord. By death of a partner. My lord, opening word is subject to contract between the partners. The contracts means the partnership deed itself. So, on death of a partner, if there is nothing on the partnership that it will continue, then it is dissolved. Partnership is dissolved. Now, my submission is, if further, my lord, but from the tenure of the reconstitution partnership part, that there were two partners, the deceased and his wife. Even otherwise, my lord, even if there was a contract, a partnership part requires two or more. So one cannot be a partner. It will be a proprietorship. Now, my submission is now, your lordship may furthermore, now your lordship may kindly see section 84, 184. Now, my submission here, the partnership is dissolved. No, before taking your lordship may kindly see section 4, proviso. There, 4 is definition of partnership, firm, partner, and firm name. Your proviso. Persons who have entered into partnership with one another are called individually partners and collectively a firm, and the name under which their business is carried on is called a firm name. Then you'll also make kindly come to section 7. Section 7.
partnership at will
Again. So, why I am submitting, keeping in view section 42C, this. If the partnership is at will, it is automatically dissolved on death of one. Then section 8 again. A person may become a partner with another person in a particular venture or undertakings. Then 18 again. Then section 18. Section 18, my lord.
yes
Partner to be an agent of the firm. Subject to the provisions of the Act, a partner is the agent of a firm for the purpose of business of the firm. So, why I am submitting, next I will take your lordship to section 184. So, a partnership firm, a firm cannot be an agent. A partner will be an agent of the firm, but not the firm itself. So, now your lordship may kindly come to section 184 of the Contract Act.
contract act easy yes section
184, madam. Who may be an agent?
yes
As between the principal and a third person, any person may become an agent, but no person who is not the age of majority and of sound mind can become an agent, so as to be responsible to his principal according to the provisions in that behalf herein contained. So my submission here, only power of attorney holder is an agent. An agent must be a living person, according to this 184. So a partnership firm cannot be an agent, so as to have a power of attorney. So, my lord, the power of attorney,
Yes.
if the power of attorney is, your lordship will find that it is a registered one, then it is in respect of the partner, not the partnership firm. Even though the nomenclature in the deed is the partnership firm represented by the managing partner. So on this, my lord, now my submission is, on death of the managing partner who has acted as an agent of the firm, the partnership, the power of attorney is no more in force. It has spent its force. It is elapsed. Partnership, sorry, power of attorney is elapsed. On death, if your lordship will hold that it is in the name of the managing partner. Furthermore, if your lordship, yes, it can hold that if it can be in a partner's name of the partnership firm, partner it can be a power of attorney holder, then by virtue of section 42C, since the partnership has dissolved, so the power of attorney has elapsed its force. So also to the development agreement which are notarized. Now on this point, now your lordship may kindly see the next provisions, section 200, 207 of the Contract Act, 202. Madam. Where the agent has, sorry, 201, sorry, madam, sorry. Termination of agency, this is important. An agency is terminated by principal revoking his authority, or by agent renouncing the business of the agency, or by business of the agency being completed, or by either the principal or the agent dying. So on death of either the principal or the agent, the power of attorney is automatically terminated. So there is no power of attorney in the eye of law on the death of Vibhuti Bhushan Patra on 14/12/2020. Now, the lordsman, here my lord, my submission is furthermore that for the reason best known to the defendant, they have not brought on record the old partnership deed. The partnership deed, which was in between the managing partner, Vibhuti Bhushan Patra, and his wife, is not brought on record. Unless and until that is brought on record, had that been brought on record, it would have been whether that is a partnership at will, or whether there was a contract that after death of one, it can be reconstituted by taking other partners. Nothing is there on record. Now my submission again is here that now they have filed an application, document showing that in January 2021, they reconstituted the partnership. Question of reconstitution does not arise here, because the partnership which was there but not brought on record has dissolved, and it is a completely new partnership firm consisting of the wife, son and daughter of the deceased managing partner Vibhuti Bhushan Patra. It is completely new entity. It is not that it was a company or other things, it will anywhere. And law is well settled, my lord. If the partnership is dissolved on death, only the legal heirs will be entitled to the share of the deceased partner on the partnership firm, not against the third person.
Yes.
Now, your lordship may kindly see the second partnership deed is registered by the IGR. And when your lordship may kindly see that document, my lord, it is not with me, my lord. That is exhibit F is the deed of reconstruction of firm.
Yes.
It is dated 5th January 2021. So there is no partnership from 14/12/2020 till this date. Though the name has been given, it is completely a new partnership.
କେବେଠୁ କେବେ କହିଲେ କହୁଛନ୍ତି ଆପଣ?
Again, 14/12/2020 Vibhuti Bhushan Patra expired. And as per document, it was a two-man partnership, my lord.
Yes, sir.
Partnership. Husband and wife. Now husband expired, only wife remained. Either way, on death division or single one, it will become proprietorship concern. Now this is constituted held on 5th January 2021 by taking into, my lord, 2 and 3, son, a daughter and son. And then you'll also kindly see Exhibit D, farm registration certificate. Exhibit D, my lord. G and G. D and G, you'll also kindly see. That copy is not with me, my lord.
Exhibit D. 3/4/2007.
Na.
12/3 12/3 से डेट ही.
Exhibit D.
Yes, D. Which is the acknowledgement of registration of farm.
Yes.
Se data कौन है? 12/3 अच्छी बाकीटा लिखी जाइए.
So that is after this, my lord. This reconstruction date. And then G also kindly see.
Exhibit G.
G. My land pen says, my lord, that is Exhibit D is dated 12/3/2007.
The original टा था.
Original. That is the partnership which is dissolved.
But that is the original certificate.
Yes, yes. That is dissolved.
That is dissolved already.
Again.
The
Then
new-
G also mechanically. That is. G also mechanically.
This is 29/4/2021.
Again. Yes. So this Exhibit G cannot inure to the benefit of the earlier partnership firm. Now, to sum and substance, my lord, you know, I will again take your lordship to two decisions. That is flag F, my lord. You will also kindly see flag F.
Of your written note.
Again, no, don't.
ଯୋଉଟା ଦେଇଛନ୍ତି ଆଚ୍ଛା ଆଚ୍ଛା.
Sorry, flag D, my lord. Sorry,
Yes, flag D.
D. You will also kindly turn to paragraph 17. Reference style.
Who is your associate, by the way? Who has prepared this? नहीं flag का एमिति कर दिया जाएगा ना. ABCD कर एमिति कर दिया जाएगा ना. गोटे जाकर देले एमिति कर दे. एतिके एतिके पुनी एतिके ऊपर को केवल एतिके हो half inch. So practically you will find it very easy to.
Again, बात कर बात.
तातल रोलेट केम देखिए पुटा.
Again, 2024 volume 2 current civil cases 198 Supreme Court, my lord. Flag D, my lord.
Yes.
You will also kindly directly turn to paragraph 17. 190. Paragraph 17.
Paragraph 17. Yes.
Yes. The fact that the farm defendant number 1, namely such and such, was a partnership at will, is not in dispute. It is also not dispute that one of the partners of the farm, namely such and such, expired in the year 1984. This event leaves no room for doubt that the partnership would stand dissolved automatically on death of the partner as per section 42C of the Act. Then last to go again. This court held that the term of section 42C of the Act, the partnership stand dissolved upon death of the partner. Then again, E টা দেখুন kindly E, flag E, that is 2021 volume 9 SCC 796 paragraph 4, 6 and 16. Before that, to take the fact again, paragraph 1 tar fact টা আছে এই টিকে খালি ছুটিয়া paragraph The challenge in the present appeal is to an order passed by the High Court of Uttarakhand in review application number 105 of 2008 on dated 23rd 4 2000, wherein the phantom of death of Pradeep Kumar, the successor in interest of Tikaram, the tenant, was not considered. The argument of the appellant was that the partnership between Pradeep Kumar and Subhash Chand, respondent for hearing, came to an end automatically on the death of Pradeep Kumar on 21/5/2024. Therefore, tenancy also has come to an end in view of section 12. So other things are there. Then you'll also kindly see paragraph 4 first. Before paragraph, my lord, where a landlord tenant matter and the tenants were partners. One partner expired. Then by order of the court, it was substituted by his legal heirs. Furthermore, the legal heirs expired. Thereafter, this fact was not taken in by the High Court. Then review was filed. It was also not taken in consideration. Then SLP is allowed. You will also kindly see paragraph 4 towards the last sentence. It is thereafter the appellant filed an application for review before the High Court, inter alia on the ground that pursuant to the death of tenant Pradeep Kumar, that is one of the partner of the firm, the partnership does not serve in view of section 42C of the Partnership Act. That's what it meant. Then paragraph 6, madam. Such review was dismissed by order impugned in the present appeal on the ground that the petitioners have entirely set up new case and the grounds are different from the writ petition. As on record, both the partners, that is Pradeep Kumar Subhanshu, died on 21/5/2004 and 25/6/2014 respectively. Hence, now the argument is that in terms of section 42C, the partnership stand dissolved by law. There is no clause in the partnership deed which permits the legal heirs of the deceased partners to continue with the partnership further. Therefore, by operation of law, the partnership has become an end, has come to an end. Then paragraph 16 again, the consequence.
Yes.
Therefore, with the death of both the partners and not having any clause permitting continuation of the partnership by the legal heir, the non-residential tenanted premises is deemed to be vacant in the law as the tenant is deemed to have ceased to occupy the building in view of the other things are there. So my submission is here with this paragraph 16 that since there is no document before lordship to show that the partnership which is dissolved will continue after death, and by taking into record or deed by the legal heir of deceased partner. So on death of that partner, the deed, the development agreement and the power of attorney has lapsed, is terminated automatically. This is my submission. Now I will take your lordship to the why I have filed the present suit.
I think we'll close it for today.
31 টা পড়ি দেবে আর কিছু কইবি এটা সরজিও নাই লর্ড
Sarju, aji pura
না না এতিকি ছাড় দেবি সেকশন 30 जोटा कहूची आगे
No, Sarju, please.
31 টা ছাড় দেলে মোর এই পার্টটা সরজিও কালি ভাই পর দিন করিবি কালি রহিবেনি আগে
Sir, rohik ni kuch.
আই না লাগে
ମୋର କିଛି କହିବାର ନାହିଁ it is his personal inconvenience I don't know
ଆଜ୍ଞା ସେକ୍ସନ 31 ସ୍ପେସିଫିକ ରିଲିଫ ଆକ୍ଟ କାଟି ଦେଖନ୍ତୁ
Specific review act bar kar.
why I have filed this suit. Of the specific relief act.
Section 31, yes.
31. Any person against whom a written instrument is voidable, and whose reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may in its discretion so adjudge it and order it to be delivered up and cancelled. Now my submission is that, to reiterate, on death of one of the partner, the partnership got dissolved, and the power of attorney also the development agreements stands terminated, and his legal heirs under no circumstances can step into there and continue with those things. So now my submission is, because if those documents are allowed to stand, that will create dispute, cloud in my right at international possession over the property in question. Hence, I have filed this suit.
शुक्रवार
ସାରିଦେବେ କିନ୍ତୁ ଯୋଉଦିନ ଏଇ ୱିକରେ ମୁଁ ସାରିବି ଆଜ୍ଞା ଏଇ ୱିକ ଆପଣଙ୍କୁ ନେବେ ଯୋଉ ପାସ ଘର ଗୁଡା ମ୍ୟାଟର ସବୁ ରହିଯାଇଛି ପରଦିନ କରିବା ସାର୍ ଶୁକ୍ରବାର ୟୁ କ୍ୟାନ୍ ଗିଭ୍ ୟୁ ରିପ୍ଲାଏ
No, I will give reply plus note of argument.
On Friday?
No, on Tuesday, 10th.
ଏଇ ୱିକରେ ସାରିଦେବା ଆଜ୍ଞା ଏଇ ୱିକରେ କ୍ଲୋଜ କରିଦେବା
ସିଏ ତାଙ୍କର କ୍ଲୋଜ କରିଦିଅନ୍ତୁ ମୁଁ ମୋର ଯାହା ରିପ୍ଲାଏ ଦେବାର କଥା ମୁଁ ରିପ୍ଲାଏ ବି ଦେବି ନୋଟ୍ ଅଫ ଆର୍ଗୁମେଣ୍ଟ ବି ଦେଇଦେବି
ଗୋଟିଏ ଦିନ
ହଁ ସେଇ 10 ତାରିଖରେ
ଗୋଟେ ଦିନ I'm willing to grant you half an hour will be
I may not need half an hour.
Very good.
I may not need half an hour to reply.
No, that's all right.
Your lordship must have marked that I am very brief and up to the point.
No, I will never comment on that, but I'm just to adjust the bar, other matters.
No. I have.
It is my job to hear, sir. I'm being paid for that.
So he will argue on
इलेक्शन केस करते पुराना 5 नंबर कोर्ट रे महकिलो साक्षी देला कोन खाइलु ना खाइले के तीन कुणिया ता भितरे छणा है कि कोन था आ कोन खाइलु ना मीठा के सब माने नरम चुपड़ी देले रस बाहर देला
शुक्रवार आसियो तो
ये तो रहिला लिस्ट शुक्रवार दिन कॉल आउट हबो नहीं आप परदिन करियो बोली परदिन से सारी दियो से परदिन सारो माने इफ आई कैन रिक्वेस्ट यू टू कंप्लीट इट बाय फ्राइडे देन से आई विल क्लोज इट दिस वीक आ आरो वीक को अन्य पाठर मैटर अछि
हां
सरीगला
हमें नोट ऑफ आर्गुमेंट दे दबो से भी दे दम से विषय 10 रे दे दियो तो ताका नोट ऑफ आर्गुमेंट
आरो वीक को नो टिके मु आई एम नॉट वेरी कीन टू टेक इट टू नेक्स्ट वीक इट विल अपसेट माय यू नो So return note परे दे परे रो आपण सो
केवल गोटे रिक्वेस्ट मु जो दिन रिटर्न नोट देबी 10 तारिख रे कहूची सेही दिन शॉर्ट हाफ एन आवर रे रिप्लाई भी दे दे
तो रखि दार वीक हैला एटा आपण साथ दियो तो साथ पर
Pardon my loss. Item 14 weekly list. I missed the ସେଥିରେ ଆମେ କପି ଦେଇ ଦେଇଛୁ IF respondent number 5 file cross objection ଆମେ ଆଜି କପି ଦେଇଦେଲୁ ଆପଣଙ୍କ order
I have already said that give a copy so
I have already filed
nothing further no further order needs to be passed
only adjournment is 1 week time to remove the defect
କେବେ ରହିଛି
item 14 respond
7 October तो अच्छी
आया within a week we will remove the defect oblige
So item number 7
ଟା के आलो पुणी
ସେ ଆଉ ଗୋଟେ ତ ଅଛି
नहीं एडमिशन मैटर्स न माने
ଆପଣ ବୋଧେ ଅର୍ଡର୍ସ ପରେ ପାସୱାର୍ଡ ଏଟା ଡକା ହେଲା
ନା ଡକା ହେଲା ମାନେ ଏଇ ମ୍ୟାଟରଟା ପାଇଁ କେବଳ ଡକା ହେଲା ହିୟରିଂ ଟା ଆଡମିସନ ନେଇଯିବା ଆଡମିସନ ସରିଲା ପରେ
ଏଟା ପୁରା ଏଡଜଷ୍ଟ ହେଲେ ଡକା ହବ ପାସୱାର୍ଡ ଟା
ହଁ naturally
ନାଇଁ
only those hearing matters that I have said that because I had originally said that it will be taken up after recess since it reached before recess That is why
Mine. Item number 28.
admission order into admission or solicitation.
But in this case, there is a mistake that consolidated cost title incorporating the name of LS of A, B not yet received. Today I am filing my lord, and the matter may be taken up for hearing any day, your lordship.
It has been admitted.
Yes, my lord. The opportunity has already appeared.
Order 41 the case,
My lord.
Why did it come?
Opportunity has already appeared, and in the meantime, 4 to 5% died.
No, substantial question of law has not been framed.
Not been framed.
We'll frame it today.
My lord.
We'll frame it today. Who's appearing for the other side?
Other side, my lord, Mr. Abhijit Pal, my lord.
It's all right. We can only frame the substantial question of law and then after take it up for hearing if everything else is there.
Yes.
Now the substitution matter is
For substitution, the matter is lingering till today, my
no,
lord.
that has been that is all taken care of.
All taken care of. All have been substituted. Appellants, respondents, all have been responded.
Delay condoned.
Delay has been condoned.
Delay condoned subject to payment. 20 days delay.
Yes, my lord.
All right. Yes. What is the matter?
My difficulty is file is not available today.
Tomorrow. Weekly list to tomorrow. Pass over.
Tomorrow. Shall I file it today? Consolidated cost title?
Yes, please file it.
Yes.
Correct consolidated. No, you file it tomorrow.
Yes.
Item 29.
Pass over.
Item number 30.
In fact, this has been listed under order 51, but it has been admitted.
Yeah, admitted. Whether in the absence of any pleadings and oral evidence, only the certified copy of voter list of the year 1980 of Goriapur filed by defendant of appellant is not a conclusive proof with regard to the actual death. Yes, facts. So this has come for hearing.
Can we have
ମୋ ପାଖରେ ଆଜ୍ଞା ଅପିଲ ମେମୋ ନାହିଁ ମୁଁ appear କରିଛି ଏଟା
Notice like that.
ନା ନୋଟିସ ହେଇନି admission
Notice ହେଇଛି ନା? Issue notice to hearing ହେଇଛି ଆଉ.
ବସ୍ କିନ୍ତୁ ଆମ ପାଖରେ କିଛି ନାହିଁ
Yes, that was in January 2022. Hey, give her a copy. Get a copy of the appeal memo we served upon Ms. Mamata Mishra, who has appeared for the respondent. Yeah. Since the matter has already been admitted and otherwise ready for hearing, list this under the heading hearing. LCR SG. Call for the LCR. No, LCR photocopy of LCR अच्छी नहीं करो. Yeah. List this matter under the heading hearing in the week commencing. Yeah, November. We'll take it up in November. Mr. Manthi, we'll take it up in the November.
ready?
28th October तक approve ही परिवहन out के ही भी
Date fix.
in the week commencing 28th October. Yes.
31. Item number 30, perhaps there is no noting that LCR has come.
No, but it is there. Photocopy that noting रही.
I'm for the respondent, Your Lordship, in 31.
Yes. Mr. Ghosh,
Miller,
you are for the appellant.
in 31.
Yes.
Yes, I'm for the appeal.
I want caveat, Your Lordship. I have not been served a copy of the second appeal, Lordship.
No copy.
Yes, I will serve just now, but I'm submitting the.
This has not been admitted as yet.
No.
2019 matters, I find 2015 matters not been admitted.
Millers. This is a reversing against the appeal is against reversing judgment and decree by the plaintiff.
Who are you?
Plaintiff. Suit Millers was filed for declaration that the suit tank is a communal tank and the villagers have customary right over it. That was plaintiff's case in short is that the suit tank was recorded.
So this was a representative in.
Suit was filed in representative capacity. by the villagers, some of the villagers, and other villagers got themselves implemented under Order 1 Rule 10 CPC
Pro forma.
from the defendant number 6 to 22.
Pro forma.
They are pro forma. The defendant 1 to 3 are contesting defendants who claim to have purchased the suit land later on from one Vidyadhara Palai. Actually, what has happened, this land was recorded in the name of one Vaishnav Charan Das, the ex-intermediate. But there also, the suit plot was recorded as Pokhari. Thereafter, the latter ROR also records the suit land as in Rakhita Khata, also tag. Despite all these, what defendants have done in the in between, that Vaishnava Das had, it is claimed, alleged that executed a Hatapata in favor of one Bhagavan Palai. In favor of one some Palai, I'm just forgetting the name, Vidyadhara Palai, and who in its turn sold away the property in favor of defendants 1 to 3 on the basis of one illegal OES settlement under 6 and 7 of the OEA Act. Your Lordship knows that there is no settlement because if he claimed to be a tenant, so he continued a tenant under 8(1) of the OEA Act. So it is deemed tenant. There is no provision for settlement. Your Lordship knows very well. So anyway, the findings of the learned trial court, Your Lordship may agree. Page.
Issue number 3.
ମୁଁ ସେଇଟା ଦେଖେଇ ଦିଏ ଟିକେ କାହିଁ ରହିବ ଡାଉଟ୍ page 13 of my appeal memo. Your Lordship may kindly see A, capital A, 2 paras below, page 13. The finding of the learned trial court I am reading, it can be answered with confidence that the suit tank has been set apart for common use of the villagers, notwithstanding the lacking of specific recording in the ROR, and thus it can be answered that the suit tank is a communal tank. Issue number 3. Then the other part of that issue, regarding customary right, at page 15, last subpara, capital A, thus from the cumulative reading of the oral and documentary evidence on record and ratio of the case law, it can be answered with confidence that the plaintiffs have successfully proved that they, along with the villagers of Koroda, have got their customary right in using the suit tank as a communal tank. Also issue number 3. Then, my lord, next issue at page 17, that is B, capital B, blackened. It can be safely concluded the settlement of the suit land in the names of defendant 1 to 3 is not legal and valid.
This is consequential. This is consequential to the finding item issue number 3.
But they claim on that basis, so these are consequential. But my duty is to, Miller, then the C at page 18.
Yes.
The suit in the present form is maintainable. Then D at page 19, towards the end of that page, in view of the findings issue 3 and 4 in favor of the plaintiff and against the defendant 1 and 3, the plaintiffs have got a valid cause of action. Plaintiffs are entitled anyway. So, but the learned appellate court illegally set aside the important findings of tank and that customary right. So accordingly, at page 28, your lordship may kindly turn
28 of the brief.
28 of the appeal memo.
Yes.
Your lordship may kindly see, I have.
No, what was the finding of the appellate court? Please tell me.
Yes, then your lordship.
How was this finding overturned?
Yes.
On what, I mean, what ground?
Yes. I'm coming to.
अरे ये जो ये तो what अभी पहुंचे ये तो state
Milord.
state council देखा जाओ ना बिल्कुल ठीक है देखिए adjust करो. Yes, please.
Milord, page by 22, para 26, that the following observations and narrations as well as the findings of the facts recorded by the learned appellate court read as follows. Milord, A, I hold that, learned lower appellate court, I hold that the customary right of the plaintiffs over the suit tank stood abolished under section 5 of the OE Act. Where is the provision of section 5 of the OE Act to abolish suit tank? Section 5 is consequences of vesting. What happens after vesting of the land to the state? There is nothing as abolition. It remains the same as it was. And the government also, that is the collector and tahsildar who are made parties, main party, they have also denied the title, they denied the claim of the plaintiff in their written statement. Then all the observations are wrong. I have noted down thereafter. Milord, the above that finding, the above finding is based upon the following observations. How illegal observations?
I've read it. I've read it.
Milords.
ସେ ଯୋଉ ଏକପାଦିଆ ଆଉ ହାତଫଟା ଉପରେ ସେ ପଳେଇଲେ.
ଆଜ୍ଞା.
ଏକପାଦିଆ is what?
ଏକପାଦିଆ ଦେଇନାହାନ୍ତି ଜମିଦାର. Without having filed ekpadia, there can't be open tenant's ledger. So ekpadia is
No, but tenant ledger was opened or not opened in this case? What is the evidence?
सेटा sure नुहे किंतु एकपादिया ଦେଇନାହାନ୍ତି, there is admitted fact. तो एकपादिया न देले भी केमिति से ओपन करिवे जमीदार टेनेंट्स रो लिस्ट दबो by virtue of ekpadia lordship knows. तो ekpadia दबा परे ही tenant's ledger can be opened, tenant's name can be entertained. Without ekpadia it can't be. So I have drafted Milord. Then should I Milord take your lordship to other findings?
No.
Milord, I have drafted the substantial questions of law.
One.
On page 27, Milord. Page 27.
No, 28 actually.
Oh, sorry, sir. Sorry, again.
Item 1.
Again.
No, question number 1. 1 will be
1, 2, and 4 may be sufficient. 1, 2, and IV. 1, 2, IV. So, accurate cataract is a ଭଲ କି ଦେଖାଯାଉଛି.
CPK Ghosh, Learned Counsel for the Appellate. Peruse the improved judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 28 II or IV?
IV.
You are appealing for all the respondents?
Your Lordship. I am for the respondent number 1.
1, 2, and 3, the contesting respondents.
Your Lord.
Issue no notice need be issued to respondent numbers 1 to 3 as they have entered appearance through Sri
Ramesh Kumar Agarwal.
Sri Ramesh Kumar Agarwal, advocate and associates, who have filed caveat.
My learned senior name may be because my name may not be there in the Mr. Soumya Mishra and associate.
Soumya Mishra. Let copies of the appeal memo be served upon Sri.
Government also.
I have a copy.
You have a copy.
Let copies of the appeal memo be served upon the respondents. What about the other respondents? Whether notice has to be issued or not?
No, ସେମାନେ ତ supporting.
So no notice need be issued
No
to
notice need be.
the other respondents.
Pro forma respondents.
Other pro forma respondents. LCR be called for. Please this matter. In the week commencing 11th November.
32.
What is ekpadia?
After vesting of the state, the intermediary, he will give the name of the person who were tenant under him.
So what is it?
So
It also has an English equivalent. I'm forgetting it. It also has an English equivalent, and you will find it in old when we are now writing the history now. So in old records, that is in the revenue settlement earlier, beginning from 1700 so and so so and so. Settlement is Bengal. There is a term.
Tenant ledger টা পড়ে না
টেনেন্ট লেজারটা তো বড় কথা সেই সেই লিস্টটা যেটা এক্স ইন্টারমিডিয়ারি দেবে যে দিস ওয়ার দি পারসনস আন্ডার মাই এগুলো ডিটেল দেবে সেটা গোটে কোন সামথিং দেয়ার আই এম ফরগেটিং এক পদে আমি কହୁଛେ না
এসে লেখা দিয়েছে একটা দিয়ে
হ্যাঁ এক পদে তো লেখা হচ্ছে কোন ভেরি গুড অল আইটেম 32
Here is this is against a reversing judgment. There is a small genealogy at page 5 of the memorandum of it.
Who are you? The plaintiff?
Plaintiff. And there against the plaintiff is
Yes.
adopted son of Hussein.
No, late Jagannath Malik had two sons, Banamali and Lakshmana.
There is no dispute. Now the plaintiff is Banamali's grandson through Hussein.
You could say adopted son like
Adopted, yes.
Yes.
That adoption is in question.
Yes.
The other dependents are the successors of this Hon'Ble.
Nobei.
Yes. Now, the plaintiff.
Who ordinarily they would have 1/3 share.
If plaintiff is not there, they will get the entire share from Hon'Ble
Oh, because the Bhagi has died.
his interest is this.
So they will get the entire share. Okay.
So now if Hussein will be there, then sorry, Fakira will be there, son of Hussein, then 50-50.
Half each.
So plaintiff filed the suit for partition with claiming half.
On the basis of that adoption.
Yeah, as the son, adopted son. Now this adoption was disputed, and the learned trial court declared this suit, saying that plaintiff is the adopted son, and the suit property liability be partition. Now this Chopra, the Nobe's daughter.
Yes.
Defendant number 1. She filed the appeal. During the appeal, she also expired. Then his son, this defendant number 3, original defendant number 3,
Vijay.
he was transferred to the category of the appellant and continued the appeal. Simultaneously, this Chopra, who is the defendant number 1 in this suit, this is the suit that is 121 of 2006. She also filed another suit claiming that this plaintiff is not the adopted son of same.
For a negative declaration.
Negative declaration. Both the suits were tried together. Judgment was delivered.
Was it a common judgment or
common judgment? Common judgment. In appeal also, 2 appeals were preferred. Common here also 2 appeals I have preferred, but today 1 has been listed.
That is not an issue.
There.
That is not an issue. We'll call for the file. Tomorrow will whatever order has been passed here, that order will be passed.
Issue is one whether the plaintiff, this plaintiff Fakira is the adopted son of the Hussein or not. This document has been exhibited as Exhibit 3.
So why was it reversed?
Reversed on the ground that there is no date, a specific date of adoption in the document. Now this plaintiff was adopted when he was 10 days old. That is in the year 1945. The document, Exhibit 3 is a document acknowledging the deed of adoption that was executed in the year 1963. 1/4/1963. Now, the date of birth of this plaintiff is 12/5/1944. The undisputedly the learned court will also comes to a conclusion this is an ancient adoption. There is no strict proof or even direct proof of adoption is available. In spite of that, I will have a glance at the para. I'm just while admitting also page 18 of the Appellate Court judgment.
Is it internal or
internal page 18? Wrong page I have not given.
No, internal page.
Internal.
Yes.
The sentence beginning with however. However, merely because of the fact that the adoption took place way before coming into effect of Hindu Adoption and Maintenance Act and is an ancient one, the necessity of proving the same by making requisite pleading and committal evidence cannot be eschewed. Thereafter comes to a conclusion that is necessary. If it is not there in Exhibit 3, then it is.
No, he says if any suspicious circumstances exist.
Yes.
Now, what is the suspicious? But no absence of date.
There is no suspicious circumstance. Even two documents have been ignored. That is Exhibit 1 and Exhibit 4. Exhibit 1 is a document executed by the father of Chapala. It is a cell deed accepting the plaintiff as the son. That means his father has admitted that he is the son. Exhibit 4 is a document where her husband has executed cell deed, accepting this plaintiff as the son. Those two documents have not been taken into consideration. Yes, it's an ancient adoption. That document is also there where it has been written that Exhibit 3 उक्त आंभ कथारे सम्मत हेबारु आंभे उक्त पुत्र को अति बाल्यवस्थारु प्राय 10-12 दिन बयसरु आंभ गृह को आनी आंभे आंभ स्त्री को हेफाजत रे लायित प्रयत्न करले. Even though the exact date is not available because the document is being executed in the 63 when the birth is in the 1945. It is quite improbable that the exact date will be available. That is why in ancient adoptions, strict and direct proof of actual date of adoption may not be required to be strictly proved. But that has been not been taken.
All right.
I have taken 2 grounds. This is A, B, and E. I have.
Third Sri D.P. Mahathir and counsel appearing for the appellant. Appellates. Here is the improved judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 10, Rachi, B, C, and E. Hello. You have appeared for the
Respondent number 1, my lords.
only one.
Yes.
So notice has to go to other respondents. Respondent number 1 has entered appearance through
Caveat, Nityananda Behuria, my lords.
Sri Nityananda Behuria. So hence no notice need be issued to him. An extra copy of the appeal memo will be served upon him. Issue notice to the other respondents by registered post with AD, returnable within 4 weeks.
Other respondents they did not prepare any appeal. In fact, the respondent number.
So for the time being, we'll dispense.
Yes.
If you want.
Yeah,
That is at your risk. Notice to other respondents need not be issued for the time being at the risk of the.
Because another appeal is there, let it go.
All right. Notice कर दो जहाँ करा है तो है ना तो ऐसा कर दो
Should not be.
fixing short returnable date इत्यादि list this matter in the अच्छा call for the LCR लिखा दो call for the LCR list this matter in the week commencing 18th November. What IA?
For temporary injunction, that status to be.
What do you say?
No, I don't have the appeal memo as of now, my lords. Kindly on that point of injunction, my lords. If time may be given, I'll file an objection to that effect.
That status will maintain in the meantime. I will start copy.
Right.
Let him file.
I relate a copy of this application be served upon counsel for the respondent number 1 by
Appeal memo and discuss.
Copy of the IA has been served upon learned counsel for the respondent who wants to file an objection. List the IA under orders for orders on short date call on 17th September. Till such time, status quo with regard to the suit property as on date shall be maintained.
Let me say, appeal memo already served.
बाकी काली से जो तंग आरो नोबटा नहीं है सो सीट्री भी सेम ऑर्डर टा पास ही जो नहीं सीधा नहीं है सुना काली नहीं है सो सप्लीमेंट्री लिस्ट नहीं है
Number 9 of 2024.
सप्लीमेंट्री लिस्ट नहीं है इसलिए सीधा ही जो
Not. That is 9 of 2023.
Item 33.
I am for the appellants. Lordship, I'm praying for on Passover.
all right pass
Item 34.
34 Passover to ये था काली आड़ू करो.
all right pass
Item 35.
Item 35. Pass over.
Well, I am caveat that not served me copy.
Anyway, see तो ना थे क्या कर दो.
Next to that.
How password था देखिए say let him come.
36 incorporate of consolidated cost title awards. I have misplaced that petition. Can I have a look?
Yes.
And I'll put it. Can it be taken up?
All right. Sri P.V. Balakrishna, Learned Counsel for the Appellate, is permitted to inspect the court record in court. List this matter next week as prayed for.
37. 36.
Sir, Miles, kindly pass over.
Pass over.
Charge 462.
Item 38.
I guess Mr. Rathod, there was another matter which I have kept it to tomorrow. Mr. C.A. Rao is appeal.
Contentious issue of 15(2)(b) of Hindu
Yes,
Sanction
yes.
Act.
So tomorrow we'll close it. Be ready tomorrow.
My lord,
I think you had you had probably completed all your arguments.
exactly, I had completed the arguments.
You said that you wanted to cite some other decisions, if I remember correctly.
खाली क्षेत्र से गुजरात हाई कोर्ट को साइड करके आज भी यदि कंक्लूड कर देबे
ऐसे नाते हो काली तो कहो
गुजरात हाई कोर्ट रे मो व्यूटा मु जहा कहूची गुजरात हाई कोर्ट एग्जैक्टली से कहूची देखिबे अपन जा करिए.
Yes. Item 38.
My lord, item 38, my lord. Lord, see, can we take up this matter on Friday, my lord? I have taken, my lord.
Yes.
Item 38, my lord. Can we take up this matter on Friday, my lord?
All right.
But with a understanding between us that he will do it on Friday.
My lord, I'll do it Friday.
No, the understanding is with me.
No, my lord,
I will not allow you any further time.
No, my lord, because my lord, he is my senior, my lord, he is my senior, my lord. I cannot make a false commitment to my lord and senior.
No, it's all right. So, Friday pass over. Friday pass over लिखती Friday will Thursday. तो काली तो कहाँ नहीं हो? Yes.
39.
My lord. My lord, I am appearing for the VC, my lord, from Delhi, my lord.
Sir, for hearing.
My lord, only a small.
Sir, sorry. Second appeal,
My lord,
hearing,
it will take only 2
virtual
minutes,
mode.
my lord. It will take hardly 2 minutes, my lord.
Sir, I'm sorry, sir. One order for everybody. Virtually, second appeal for hearing. I'm sorry. I will not be.
Kindly give a minute, my lord. I am not here.
I
Not
have
for
capacity.
hearing. My
I will
lord.
grant you time. If you want time, I can grant you time.
What I am saying, my lord, kindly listen for a minute, my lord. Only minute I am seeking. There is a order of this
I am
honorable
going
court.
to listen patiently. Anyway, you argue.
My lord, what I am saying, I am not going to the merits of the case, my
Yes,
lord. My lord,
good.
kindly see 12(7)23 order. It is only a paragraph. There is a specific order of this honorable court. They have violated in and out. My lord, I am very happy that my lord will give a lot of time, but kindly read my lord's own order. Where they are violated, my lord. I have the photographs also to show. There is status code of this honorable court. They have not given reply. I have given the photograph. They are violating this honorable court's order, this August court's order, my lord. That, my lord, I am just reading only 2 minutes. Only take 2 minutes. I am not going to merits of the case at all, man. May I read, my lord, that order?
Yes,
that
yes.
I am saying that I. Learned and counsel for the petitioner appellant submit the status quo should be maintained in respect to the suit land, consider the nature of the dispute between the parties. It is rather alleged that the respondent number 2 is responsible for the alleged construction which is in progress. In reply, learned and counsel the respondent to submit that construction has already been over. In any view of the matter, consider the submission of the learned and counsel by the respective parties. This court is an interim measure. Directs that there shall be no further construction to be taken up over in respect to suit schedule land till disposal of the appeal. Thereafter, my lord, on 2/8/23, that is 1 year before, my lord. That is only one sentence I have read. In order to Mr. Patri, that is myself, my lord, counsel for the appellants alleges that despite an order of this court dated 12 July 2023, construction is not stopped, which is still in progress, but the same is stoutly denied by the law and counsel for the respondent. In order to ascertain whether any such construction is currently in progress or not, Mr. Patri, law and counsel for the appellant, is directed to file an affidavit with the necessary evidence in support thereof, so that a response may be invited from the other side. So, my lord, I have given that evidence also, that the excellent photographs are before my lords. You see that the construction is still going on even today. My client is my good friend is in the USA, America. And they are doing it. Every sentence, my lord, will read their judgments. After the judgment, they have called fraudulently, my lord. That will be on the merits of the case. Now, immediately, my lord, they have violated this August court's order. a constitutional court, highest court of the state. They have violated. They said the construction is over. Now kindly see the photographs.
Well, say, Sarant.
My lord, kindly see the photograph. Photograph will see itself that they have violated even today. And the person who is a adopted son who is also disputed, everything, every word.
Will
And
deputy commissioner
their
to the
wife is
spot?
a police officer.
Will deputy commissioner, Mr. Patni, will deputy commissioner to the spot to find out what is exactly going on?
Yes, my lord, yes, my lord. That is a great thing. Yes, my lord.
Yes.
That is the only thing I want. Photographs is explicit, my lord, will show that is.
This court sitting here looking at some photographs cannot arrive at any decision.
Yes, my lord. I am agreeable. My lord, I am agreeable.
2010, my lord, both the courts, they have lost both the courts.
Mr. Sahu, this court has passed on.
This is the highest court, my lord.
Justice Patnaik's order, he was just reading out. There are two orders. There is allegation, there is counter allegation. This court is not passing any final order. You will deputy commissioner? You
Yes,
may
that is the only thing I want, my lord. Yes, ma'am.
we can deputy advocate commissioner probably.
Yes,
Mr.
my lord. Yes, ma'am.
We can
That only
deputy an advocate commissioner also to this.
Yes, my lord. That is the
You
only
suggest
request,
no?
my lord.
Technical aspect is concerned.
Technical, खाली काम होउची कि ना देखिए पे technical aspect को.
କାମ ବି ହେଇଛି ଯୋଉ ଦିନ କହିଛନ୍ତି ସେମାନେ କାମ ହଉନି ବୋଲି କି କାମ ଏବେ ବି ହଉଛି ମାନେ ପେପର ମୁଁ ସବୁ ଆପଣଙ୍କୁ ପ୍ରଡ୍ୟୁସ କରିବି ସବୁ ଜାଗାରେ fraudulent adoption deed fraudulent ସବୁ କିଛି.
This court directed that no further construction should take place. No,
yes,
whatever will happen to the appeal, that's a different matter. But this
Yes,
court order has to be complied with.
Yes, ma'am.
How also you
That
as
is
an
the only
you should
Yes,
also
ma'am.
be interested in seeing that this order of the court is complied with.
My lord, I am assured this honorable court that this person will be behind the bars. I assure this honorable court the document they have produced before this will be behind the bars. My lord will order from that straightway. They will go to the Jharkhand or South jail. I will prove that. Prove beyond any reasonable doubt also. I will prove that they will
Yes,
go
yes,
to jail.
yes, Mr. Sahu.
My lord, the appellant number 2 residing at Paris. My lord, they filed affidavit. Your lordship kindly see the affidavit. And see, my lord, deposed, my lord, the construction is going on at Sundargarh.
He is not staying in Paris. He is staying in Tallahassee in USA, not Paris.
Sarant. Yes.
Let's say filed some photographs which is not related to the shoot land. If your lordship, my lord, it's a my lord right time to depute commission.
Yes, ma'am.
Depute commission and the affidavit filed by the appellant number 2. My lord, there is no whisper. What is the source of knowing the my lord kama hochi ki no hochi kichi again? There is no whisper.
He has an interest in the property.
My lord,
Why should we be interested in his source?
another submissions, the appeal is not admitted. Your lordship kindly see it. The appeal has been filed since 2010. Thereafter, my lord, the appeal is not admitted, and both the courts, my lord, found in favor of me. And thereafter, my lord,
In spite of that, an order of status quo has been passed by this court.
My lord, we are before the High Court of our state, my lord, the highest court of
So
the state.
both of you can suggest somebody's name.
I will leave to my lord. I will leave to my lord. I will leave to my lord.
ଯୋଉମାନେ ଆପଣ କହୁନାହାନ୍ତି ବାହାର ତରଫରୁ କାହାକୁ କାହା ନା ଆପଣ କୁହନ୍ତୁ. I will
No, no, I will leave to it because sometimes also
Mr. Amit Prasad Bose, I don't know.
Any person, my lord, of your
Yes,
confidence.
Mr. Bose is there. He is very well versed and proficient in civil law, at least more than me. So naturally,
No, no, my lord, I am a small man. I am a tall man, but small man. I will give a gist of the cases, my lord. If I
All
read,
right.
my lord, please, I will see that.
by order dated 12/7/2023, this court in IN number 266 of 2023 passed an order directing that no further construction shall be taken up in respect of the suit schedule property till disposal of the appeal. By order dated 2/8/2023, on a submission being made by the counsel for the appellants that construction has not stopped, which was denied by the counsel for the respondents, this court directed the counsel for the appellants to file an affidavit with necessary evidence in support of his contentions. Pursuant to such order, an affidavit has been filed being sworn by Ashok Kumar Hota, enclosing therewith several photographs which purportedly show that construction is in progress. Stop. You have filed an objection?
objection of filed copy.
You have already filed?
Again.
Which copy amu diya hai, Saroj will collect the copy. Saroj is there, he can
The,
collect the copy. They have not given anything.
Sri Sahu, learned counsel for the respondents, has filed an objection. Let a copy thereof be served upon learned counsel appearing
Saroj is there in the Cuttack. Saroj.
For the appellants. In order to resolve the controversy, this court deems it proper to depute an advocate commissioner to the spot to ascertain whether any construction is presently going on or not.
After this honorable court's आज बात करें.
Moreover, how can he ascertain that? तापर तो 2/7/2023 परठू
ଆମେ ଫଟୋ ବି ଦେଇଛୁ ଏବେ ଜଣା ପଡିଯିବ ସାର୍ ଜଣା ପଡିଯିବ ଏବେ ବି କରୁଛନ୍ତି କାଲି ମୁଁ କାଲି କଥା ବି ହେଇଥିଲି ସବୁ
ସେଟା ସେ କହିଦେଇ ପାରିବେ କନଷ୍ଟ୍ରକ୍ସନ ଅର୍ ନଟ୍
ଜଣା ପଡିଯିବ ଏଇ ବର୍ଷକ ଭିତରେ ହେଇଛି ଆଗରୁ ତ କରୁଛନ୍ତି ସେମାନେ ସବୁ ଭୁଲ କରି ଚାଲିଛନ୍ତି
the cost of the commissioner ଟିକେ the cost of the commissioner shall be borne equally by the parties.
Yes.
Let a copy of the IA along with the copy of the affidavit and the objection filed today be served upon the
Saroj is there in Cuttack. Saroj.
What Saroj?
Saroj Das is one of the parties. He is available there in Cuttack. I am in Delhi.
Anyway.
Yes. Saroj is there. Saroj is more
Both party learned counsel for the parties suggests the name of Sri Amit Prasad Bose, learned counsel, who to be the advocate, to act as the advocate commissioner. Sri Bose, who is present in the court, consents to such appointment. The Sri Bose is requested to submit his report after his field visit within a week.
Yes.
Huh? By 9th of this month, list this matter on 12th. Because you will give a copy through the you will submit a report.
Let both the parties serve their respective.
The affidavit, first is the IA in which the order was passed. Second is the affidavit which was filed by Mr. Patri. Third is the objection that he has filed. All have to be supplied to you along with affidavit includes the documents, the photographs.
But I serve notice on both the counts.
Yeah, that is up to you. Should I have passed that order?
No,
The parties are directed to respond to the notices that may be issued by Sri Bose by the advocate commissioner. All right, that's what I think.
So deposit of money, sir, will pay also.
The
by some time.
Deposit both parties shall for this the office has to assess the cost. No. Then
whatever your lordship fixes, that is.
It is inside Cuttack.
No, my lord, in Sundargarh, my lord.
In Sundargarh. So Sundargarh, how do we assess the cost?
Sir, whatever you will pay, fees will also pay equal, no problem. My lord.
Yeah, that is there, but how do we assess the cost right now? You give me a bill.
My lord can fix any amount if it is more, he will pay.
That will not be possible because he will stay somewhere and then he will visit the place.
I leave it to my lord. What is yes. Certain, my lord. Leave to my lord.
25,000 let him spend it.
Let a tentative amount of rupees
10,000 each.
20,000 each. That is right. No, with equal division, he paid equal 20,000 be deposited in the registry to be disbursed to Sri Bose. Both parties are directed to bear the cost equally. List this matter on 12th. I am to bar on 12th. Supplementary list. Yes.
My lord, I am obliged. Highly obliged. I am really grateful. So I will deposit tomorrow or day after. Within a day or two.
Deposit 10.
Yes, my lord. I will deposit, my lord. Tomorrow I will deposit. Tomorrow or day after tomorrow I will deposit within 2 days.
You are for the respondent.
Respondent number 2.
Respondent
Gote. So many adopted son भी नो
no dispute 10,000 ହେଇଗଲା yes
ठीक ଅଛି
matters will continue tomorrow
12 तारिखରେ ଆସିବ matter ମାନେ
tomorrow I will not be available ତାପରେ week ସାରା ଅଛି କାଇଁ ତୁ ପାସ୍ ହବ yes
obliged ठीक हो